Good morning, everyone, and welcome back. The time is now 8 o'clock in the morning, and I would like to call the August 29th, 30th, and 31st, 2022 meeting of the Energy Facility Siting Council to order. Mr. Secretary, please call the roll.
Kent Howe,
Here.
Hanley Jenkins,
Here.
Jordan Truitt,
Here.
Cindy Condon,
Here.
Perry Chalktoot,
Here.
Ann Byer. You have a quorum, Mr. Vice Chair.
Okay. Are there any agenda modifications?
Mr. Vice Chair, just as a reminder, at the end of the meeting today, we will go back to the meeting minutes from June and July.
Yeah.
And then there was, at least thus far, one item that was pushed to the end of the meeting today, which was the notification related to the blasting plan.
Okay, right.
So that's the one remaining issue from all of the standards and issues that the council has heard thus far. So that's the one that we will return to. And we do have a proposal for council. So thank you to Christopher Clark. He did some research on that and has provided that. And Sarah's working up a proposal that we will have for council on that one.
Okay, thank you. So I have the following announcements. Please silence your cell phones. Those participating via phone or webinar, please mute your phone. And if you receive a phone call, please hang up from this call and dial back in after finishing your other call. For those signed on to the webinar, please do not broadcast your webcam. Reminder to council and to anyone addressing the council to please remember to state your full name clearly and do not use the speakerphone feature as it will create feedback. For those testifying on the B2H agenda item, please use the raise your hand feature in WebEx to speak during the public comment period, or press *3 to raise your hand if you are participating by telephone. You may sign up for email notices by clicking the link on the agenda or the council webpage. You are also welcome to access the online mapping tool and any documents by visiting our website. Energy Facility Council meetings shall be conducted in a respectful and courteous manner where everyone is allowed to state their positions at the appropriate times consistent with council rules and procedures. Willful, accusatory, offensive, insulting, threatening, insolent, or slanderous comments which disrupt the council meetings are not acceptable. Pursuant to Oregon Administrative Rule 345-011-0080, any person who engages in unacceptable conduct which disrupts the meeting may be expelled. So today we're continuing our review of the proposed order and proposed contested case order and exception hearing on the Boardman to Hemingway transmission line. We have Kellen Tardiweather, the senior siting analyst for the Oregon Department of Energy, and Jesse Ratcliffe, Department of Justice, Senior Assistant Attorney General of the Natural Resources Section. So we are ready to move to the noise control regulations standard, and we have issues NC 1, 2, 3, and 4. And so I'll turn it over to Ms. Tardiweather.
Good morning. Thank you, Vice Chair. Good morning, members of the council. For the record, my name is Kellen Tardiweather, Senior Siting Analyst, Oregon Department of Energy. I'm going to do an introduction for council for noise. I'm going to deviate a little bit from what my PowerPoint presentation had, and we are all boarding the train and we're leaving council's standards and we're headed to the realm of the other applicable statutes and rules. So this is going to be exciting, and we're going to look at some rules. And I don't want anybody to just, there'll be a lot, but I'm going to talk you through what they are. And I think that's the best way to set you up for the background for some of the pretty technical information that you're going to be hearing today regarding noise for the facility. So we are in the realm of the noise control regulations that are under the Department of Environmental Quality's noise rules. And council has seen the noise rules before, and we've talked about them. But if council has ever wondered, what are we doing making decisions about DEQ's noise rules, I'm going to show you why. And while I'm getting there, I'm going to remind council that under the council's general standard of review, the question is whether or not the preponderance of evidence supports the conclusion that the application for site certificate or the proposed facility meets council standards, council statutes, and then other applicable laws and statutes as identified, in Oregon as identified in the second amended project order. So that is where we're going. And so up here on my screen, and there is a little bit of delay. So, and this is in the proposed order. So this is why council is making decisions on the DEQ noise rules, which is just what I'm going to call them, or noise regulations. So the legislative assembly actually withdrew funding. So DEQ doesn't actually fund, administer, or generally mediate or provide input or interpretation for their rules or implementation of their rules. However, the DEQ noise rules are still rules that are apply in Oregon. Therefore, they fall into that bucket underneath the general standard of review that the council must evaluate and find compliance with. Oh, great. With my sharing bar, just as bear with me here. Okay, so this is the rule set. Let me see if I can make it bigger here for folks. It's not working. Why is it not working? There we go. Okay. Noise control regulations for industry and commerce. So I'm just going to kind of walk through here. These are standards and regulations. We're going to skip over one. Those are existing noise sources. What are we talking about? We're talking about new noise sources. So there's new noise sources and they're on previously unused or previously used sites, and new sources located on previously unused sites. And in the proposed order, the applicant provides information and representations that the site for the proposed transmission line is an unused site, predominantly using information from Exhibit K, which is information about land use. The facility crosses mostly EFU lands and some forested lands, but in general, one of the ways I think about it is like a used site would be a brownfield or already developed, or an industrial site, and an unused site would be a generally undeveloped site. The rules that fall under an unused site are more stringent than a used site. So it is a more conservative set of rules that would apply to the facility. So we're looking at this big B, little I, and then, so we're just going to kind of walk through this now. Also, what are we talking about with noise? We know we have a transmission line. We're going to be constructing and operating a transmission line. And so there's noise associated with construction, which I'll talk about that. And then there's noise associated with operation of the proposed facility. The vast majority of that noise is the corona noise associated with operating a high kilovoltage transmission line. Generally speaking, the higher the voltage, the more corona noise you may have under certain circumstances. Corona noise is most apparent in conditions that have like weather conditions that have light moisture. So like a light rain that is light enough that where the moisture would amplify the corona noise, but not heavy enough rain to where the sound of the rain would actually drown out the corona noise. So that those are kind of the conditions in which the corona effect would be the most amplified. So underneath here, the no person owning or controlling, this is where we have the two noise standards. And we have this. I'm going to stop or start with, okay. So we have this, so the noise source here, transmission line, are not allowed to increase the ambient statistical noise levels by more than 10 decibels dBA in any 1 hour. Okay, so that is one. This is one of the noise standards. We call that the ambient degradation standard or the anti-ambient degradation standard. So this is where in any 1 hour, the noise from the facility cannot exceed 10 dBA. The other noise standard is the maximum noise standard. And there's this table 8, and I have it later in the presentation, which I'll go over. So this is the maximum noise levels that are represented in this table. So those are the two that we look at. Okay, I'm going to scroll down. There are, so council will just see here, it doesn't apply, but there are separate rules that would apply to a wind energy facility. This is not a wind energy facility. So we are applying the non-wind rules. Okay. Okay, this is an applicable portion of the rules. This is some direction about measurement and where measurement of a noise source or measurement points for on gaining data to establish what the existing ambient or baseline noise is. So these are rules that provide direction about the location and measure and how to go about measurement. Okay, the sub 5 are exemptions. So there are explicit exemptions for noise under the DEQ noise rules. One of them and the proposed order does talk about several exemptions. The one that really that kind of council is the most familiar with and that we talk about in the proposed order is the exemption for sounds that originate from a construction site. So noise associated with constructing a facility is exempt from these noise rules. They contemplate that construction may be noisy. However, there is a lengthy explanation of noise associated with construction in the proposed order, because that's also where we talk and we pull in the assessment under recreation, protected areas, and scenic resources. We point to that evaluation to give an idea of what the noise associated with construction may be. Okay, and then we have under this sub 35 of the noise control regulations, there are exceptions. Just give me a moment. I'm going to check with my notes to see if I need to go back to my PowerPoint and if I'm on target here with what I want to say. Okay, very good. Before I go into exceptions, and I'll just leave these here, but I wanted to talk about and to give some background about ambient or baseline noise levels. So here, really what we're doing, and these are for all of council's facilities, what is modeled is the worst case noise that could potentially come out of a proposed facility. So with other types of facilities, we generally talk about, for example, with like a solar facility, what is the noise generating equipment? And it's usually associated with the transformers and the equipment associated with any battery storage. And an applicant has to model the most possible equipment that they're proposing and put that into their noise assessment. Here, part of the noise, the maximum or worst case noise that we're talking about is the corona noise. And so what the applicant has provided in Exhibit X, which has information about noise, is the worst case noise or situation where corona would be the worst. So that is kind of one bundle of assessment that goes over here. But then, because these are not existing facilities, these are proposed facilities. So we're projecting ahead and we're modeling, and part of that modeling has to take into consideration the existing noise levels at a site. And that is the baseline or an ambient noise level. Because, and we can just run a scenario of, say that we had a facility, or this facility was crisscrossing or right adjacent to I-84, as opposed to maybe Hanley's house, which is rural and, you know, nestled, and it's very quiet and peaceful out there. The ambient noise next to I-84 is going to be louder. And so therefore, any noise from the corona noise from a transmission line, even in the worst case scenarios when it's the loudest, likely would not even be heard because the ambient noise is so loud. However, out at Hanley's house, it is it's rural and it's quiet. Your ambient noise are the sounds of maybe dogs barking in the distance and birds chirping and some maybe traffic far away, airplanes. These are the ambient noise levels. So this is what all applicants have to establish. And so that there is ambient noise monitoring, where the applicant goes out into the field, positions monitoring devices and measures during the day and during the night in time spans, and then takes the most, again, we're applying the most conservative assumptions. So usually what's used is the ambient noise level in like late night, early morning, when it's just the quietest. And that is the ambient assumed for that site all the time. So it's the most conservative. And then we add that, we take that ambient and then add on the projected maximum corona noise. And that's what is applied to that ambient degradation standard of the no more than 10 dBA per hour and the maximum noise. So those are kind of a very high level summary of those two. So, and we will get to this, and the applicant has conducted that modeling, and there are several areas where the applicant does not meet or exceeds the anti-ambient degradation standard. So the noise level in any hour would be more than 10. So there are several instances in this. So the applicant in its application has requested council consider and apply an exception to the noise rules. They also are requesting a variance to the noise rules in these situations. So I'm just going to work, we're going to look at these rules here. And this is the findings that are provided in the proposed order. So for an exception, upon written request from the owner, this would be the applicant, the department may authorize an exception to these noise rules that I've talked about. And then these are the circumstances, this A through E, the circumstances under which an exception may be granted. The applicant is representing that the corona noise would be an unusual and or an infrequent event and provides evidence to support that representation. So that's the exception. So in here, it tells us to point here. So go here. So we're going to go there now. This is exciting. Okay. So here we are. And so this is what the department does. We read rules and we see what an applicant gets us and we draft findings. So in establishing an exception, department shall consider protection of health and safety and welfare of Oregon citizens. And then we also consider feasibility and cost of noise abatement, the past, present, and future patterns of land use, relative timing of land use changes, and other legal constraints. For exceptions, the department shall specify times. So all of these items in here, the department has evaluated in the proposed order and made recommendations. So each of these aspects is represented in the proposed order. And then, and so the council, as the decision maker for these rules, has the authority to do this evaluation and grant or deny these exceptions and apply the noise rules. The applicant is also requesting that council consider a variance to the noise rules. So the commission may grant specific variances from the particular requirements of any rule, regulation, or order to for such specific noise sources upon conditions as it may deem necessary to protect the public health and welfare. If it finds that strict compliance with rule, regulation, or order is inappropriate because of conditions beyond the control of persons granted such variance. Or because, so we're going to go procedures for requesting. So this is the second part in the proposed order where there is an evaluation and recommendation for council's consideration. Okay. Let me go back here. That was kind of a lot of rules. And we can go back to that and maybe I'll just proceed. But if council has any questions about those, we can do that now or at the end. So just give me 1 minute. I'm almost through here. Maybe. Okay. I had these snippets of rules in my PowerPoint and I just thought that it was better to actually just look at them. So under there is table NC4, which is the summary of acoustic modeling results, comparison of predicted facility sound levels to late night baseline. It provides the results of the applicant's noise modeling. So this is their establishment of the baseline at representative locations. And then it also, and so it includes the baseline or ambient and then their maximum modeled. And in that table, it does include the results of the anti-ambient degradation standard. So the increase of 10 dBA per hour, but it also has the results of the maximum allowable. And in that table, the maximum noise at any, and I forgot to give council the background. Council has heard it before. In the DEQ noise rules, they call them noise sensitive properties. In general, those council can think of those as their properties normally used for sleeping. That's part of the definition, but it's a residence. That's what we're looking at. They're called noise sensitive properties. In the application and just in the department's vernacular, we commonly call it an NSR or a noise sensitive receptor. So the NSR or noise sensitive property that has which would experience the loudest noise, it would be at 47 dBA, which is underneath the 50 dBA, which this is that table 8 that those noise rules pointed to. This is just taken out of DEQ's noise rules. And again, we're kind of we're going the most conservative, which is the L50. When council sees the L50 is generally the statistical noise level that is the quietest. So everything is kind of the most conservative application within these rules. So so when we talk about maximum allowable, 50 dBA is that threshold because it's in here. It's the most conservative. It's the lowest noise. And in that table, at the NSR, it would be 47. So we're recommending that the maximum allowable noise standard is met. And that concludes my portion.
Thanks, Kellen. So we have 4 issues that are part of the contested case that exceptions were filed on related to the noise standard. We're going to take those issues one by one. So our first issue is NC1. The limited party here is Stop B2H. The issue is whether the department improperly modified/reduced the noise analysis area in Exhibit X from 1 mile of the proposed site boundary to 1/2 mile of the proposed site boundary, and whether one of the department's application rules, so one of the application materials rules in Division 21, requires notification to all owners of noise-sensitive property within 1 mile. So the proposed contested case order opinion, the hearing officer found that the department's application rule does require that an applicant identify and address and include addresses for noise-sensitive receptors within 1 mile of the site boundary. A separate council rule allows for the department to modify the information to be required in an application for site certificate if that modification is reflected in the department's project order. We've heard about the project order a few times, and again, that is the document that is intended to provide the roadmap to the applicant for the standards that are going to be required to be met in the application process. In this case, the project order was amended a couple of times. So in the second amended project order, the department modified the requirements of the application requirements to accommodate the linear nature of the proposed facility, and established that the extent of the names and addresses that must be identified for noise-sensitive properties extend to 1/2 mile from the site boundary rather than 1 mile. So one of the issues raised by Stop B2H was whether or not the department's authority to modify these application requirements are limited to a situation where the applicant has made a written request to waive requirements. The hearing officer found that, well, that provision does authorize the department to modify requirements upon the applicant's written request. It does not preclude the department from otherwise establishing on its own the applicable application requirements in the project order. Separately, and we're, getting a little technical here, but the rule that refers to the mile boundary, the hearing officer found that that's not a requirement for issuing public notice. Public notice and entities that must receive notice are addressed in separate department or council rules, and that further the rule at issue here does not establish or define the noise analysis area. So the hearing officer's ultimate conclusion here was that separately from modifying the information requirements in the application, the department acted within its authority and established the noise analysis area in the second amended project order as the area within and extending 1/2 mile from the site boundary. So again, that's the summary of the hearing officer's proposed contested case order opinion, and we'll now hear an oral argument from Stop B2H on this issue.
Morning, members of the commission. My name's Carl Anuda. I'm representing Stop B2H. First, let me point something out to make sure that we're all clear. Stop did not accept on the issue of notice. Stop only accepted on the issue of the modification in the project order of a pre-existing rule. And this is an interesting legal issue. hopefully the council has thought through this. The basic problem here is that you have an existing rule that says 1 mile is what's required for the list. The department's position is that you have another rule that allows you to modify that rule in a project order. And the problem for you is the Oregon Administrative Procedures Act, or APA, is what governs rulemaking, and it does not provide for having a rule that lets you modify a rule in an order. It has very strict prescriptions. You have to go through a rule-making process that publishes notice and does all the things that the APA requires. That, there's no dispute, that didn't happen here. So the really simple, direct issue is, can ODO pass a rule giving itself an exemption from the Administrative Procedures Act rule-making or rule modification requirements? STOP's position is straightforward. No, every agency is bound by the APA. If you want to change a rule, you have to go through rulemaking. You can do that on a temporary or emergency basis if you find that there's an emergency. Not sure how you could find there would be an emergency because the power company wants to make a lot of money building a line, but maybe that would, they could try to argue that. But here there was no effort to get an emergency rule passed. There was no amended rule that you could apply in a project order. You had the existing rules, and instead the department modified the rule to say something that it didn't say. So our position is very straightforward. You don't have the authority to do that. You, the council, should tell the department, make them go back and do it correctly. And why does that matter? Because that list that they create provides the public or you the ability to look at what noise sensitive receptors are out there and what might be covered by the project boundary or the project 1 mile radius. And that's something that the public should know. That's why your rules require that notice within a half mile. You now have a whole group of people that were between a half mile and a mile that could never figure out, because the list wasn't accurately done, whether they were on the list or off the list. And that's what happens if you change rules in the middle of a proceeding without going through the APA. I'll be happy to answer questions if you have any.
Thank you, Mr. Anuda. Any questions from council? Thank you.
Mr. Anuda is asking you to look at one portion of your rules and to, excuse me, I seem to have some sound going on here. Could I pause my time? Thank you. I seem to have made all kinds of mistakes. Okay, I think that's better. All right, and again, for the record, I'm Lisa Rackner. So Mr. Anuda wants you to look at one portion of your rules, which are the requirement lists for Exhibit X, to read that all by itself and say you can't change that rule except to do so under the APA. But that's not the way you look at a set of rules. Basic principles of statutory construction require you to look at all of the rules and construe them together. And if you do that, you will see that ODO definitely had the authority to make changes in the project order to the analysis area for noise. And I hate quoting quoting rules by number, but I think it's helpful to do so. OAR Chapter 345, 21.0004, that section provides that ODO may waive or modify any of the application content requirements listed in Chapter 21 that ODO determines are not applicable to the proposed facility. Similarly, 345 21.000101 states that the project order identifies the provisions of this rule applicable to the application for the proposed facility, including any appropriate modifications to application of the rule. So clearly, within your rules itself, Odo had the authority to make a revision to the analysis area in the project order, and that is exactly what they did. There is no reason for rulemaking. There is no error that was committed on a procedural basis here. I also want to point out that while Stop B2H is stating that they're concerned that people on that list going out to a mile may not have had proper notice, at the same time they've said, and this is true, in their exceptions, they didn't raise a notice argument. So I think that's a red herring. And the final thing I just want to emphasize is while Odo did reduce the analysis area at the outset, Idaho Power did analyze for noise effects only out to a half a mile. Ultimately, in response to concerns, and this is a familiar refrain you'll hear, Idaho Power heard concerns. Idaho Power ultimately expanded its analysis area out to 1 mile, and as a result found one additional exceedance going out to 1 mile. So in the end, the analysis area was out to 1 mile. And finally, in the site conditions that were adopted by the hearing officer, ultimately Idaho Power is going to have to update the list of landowners going out to 1 mile, provide them all with notice of the conditions that are adopted in the site certificate, so that everybody going out to 1 mile is going to understand what the rules are around noise, what mitigation they might be entitled to, and what the process is for complaints. And I see I've gone over. Apologies.
Thank you, Ms. Rackner. Are there any questions from council? Guess not. Council Rowe.
Rowe, Department of Justice, or the Oregon Department of Energy. I've said this before, I think, at least internally, this is an issue that only an administrative law professor could love. I don't have much to add to what Ms. Rackner said, but I will, always good to hear things a couple times to help you make sure you're following. The rule at issue seeks only a list of names and addresses of noise-sensitive receptors within 1 mile of the proposed facility. It doesn't establish a public noticing requirement, and it doesn't establish an analysis area. That rule doesn't say you have to analyze noise within 1 mile. It says give us a list of the NSR properties within 1 mile. Council rules don't specify an analysis area for determining compliance with the noise control regulations. There are statute as well as rules that provide authority for the department to establish application requirements in the project order. Okay, so what was done here isn't being done just pursuant to a rule, it's also being done pursuant to a statute, which says in the project order, the department shall establish what statutes, rules, council standards apply to the application. Consistent with that authority, in the project order, the department set the noise analysis area at a half mile of the site boundary. Even if the Division 21 rule at issue required analysis within 1 mile, which it does not, the department would have authority to modify that provision consistent with the statute as well as the rules that Ms. Rackner just mentioned. Also, as Ms. Rackner mentioned, all of this is essentially moot, because even though in the project order the department said analyze within half a mile, Idaho Power ended up evaluating noise-sensitive receptors and potential noise impacts extending out to 1 mile in response to public comment and concern about this issue.
Council Rowe. Any questions from the council? Okay, do we want to continue our practice of taking on each issue and resolving with the straw poll for the proposed contested case order one at a time? Yeah. Council Condon.
Cindy Condon, just a question for the department. What was the reasoning for the half mile? Just general reasoning for half mile?
Hello, for the record, Callan Tardyweather. That was established prior to Sarah and I being here. After the establishment of the analysis areas happens after the notice of intent phase, where there is a comment period, and we ask reviewing agencies to comment on if they have any feedback about analysis areas. Agencies generally don't comment on noise, but just for council to take into consideration that we take that information, and then that's the basis that we modify analysis areas. And then your rules tell us to establish that in the project order, which happens after the notice of intent phase. The intent is just that it is a longer linear facility, and to have it's kind of like a reasonable factor. And this is just in conversations and our understanding with the people that did establish that, because it happened prior to Sarah and I being here. But that because it is this long, 274-mile linear facility, that a reasonable analysis area, that basically going out a mile would just be a really big and maybe unnecessary analysis. This is just from my understanding. We don't actually have anything in the record that has a basis or a reason for it.
Okay, Secretary Cornett, I believe we're ready for the straw poll.
Okay, this would be to agree with the findings. So for the record, Todd Cornett, agree with the findings of fact, conclusions of law, and conditions of approval in the proposed contested case order pertaining to issue NC1.
Sounds right?
Kent Howe,
Yes.
Ann Byer,
Yes.
Hanley Jenkins,
Yes.
Jordan Truitt,
Yes.
Perry Chalktooth,
Yes.
Cindy Condon.
Yes.
Thank you, council members.
The next issue is issue NC2. We have several limited parties associated with this issue. Stop B2H, Gilbert, and Horst. All three of these limited parties filed exceptions. The issue is whether the department erred in recommending that the council grant a variance/exception from the Oregon DEQ's noise rules, OAR 340-35-0035, and whether the variance/exception is inconsistent with ORS 467-010. So the hearing officer's opinion on this issue first notes one of the council's statutes, ORS 469-370 sub 7, which establishes that the council must determine whether the proposed facility complies with any additional statutes, rules, or ordinances determined to be applicable to the facility by the project order as amended. So again, this is setting the stage that these noise rules come from another source of law, not the council's own rules in the first instance, but the DEQ noise rules. ORS 469-401 establishes the council's authority in consolidating other permits or permit requirements into the site certificate. Based on these statutes taken together, the council has the jurisdiction and authority to determine whether the proposed facility meets DEQ's noise control regulation requirements for an exception and or a variance from the ambient anti-degradation standard. And that standard is a limit not to exceed more than 10 dBA above the baseline ambient noise levels in any 1 hour. And further, that the council is not required to consult with the Environmental Quality Commission or DEQ in making its determination. The hearing officer found that 30 years ago, the Environmental Quality Commission and DEQ suspended their responsibilities for administrating the noise program. And essentially, this places the council as the sole authority to make findings and rules on an applicant's request for variance and exception, just as it does to the council's authority to make decisions with respect to any aspect of the noise rules that may apply here. The hearing officer found that the limited parties presented no persuasive evidence that the department's recommendation that the council grant a variance or exception was an error. The hearing officer found that exceedances of the ambient degradation standard meet the criteria for being considered unusual or infrequent because it would occur less than 2% of the time, only during foul weather, where foul weather is infrequent in the project area, and at times of low ambient noise levels, and when the transmission line is operating at full capacity. ORS 467-010, which is the legislative policy behind the noise control rules, states that it is to provide protection of the health, safety, and welfare of Oregon citizens from the hazards and deterioration of the quality of life imposed by excessive noise emissions. The hearing officer found that the proposed facility will not present a threat to the environmental quality of life in this state. The department that the department appropriately considered the factors under AR 340-35-0010 sub 2. The hearing officer also noted the noise conditions that have been imposed here. Noise condition 1, which is a pre-construction requirement to work with known NSRs where exceedances would occur, and agree and implement noise impact related mitigation. And second, a post-construction requirement to evaluate any noise complaints and implement noise impact related mitigation if the complaint is deemed valid. This includes a council review component if any disputes on the level of mitigation end up being unresolved. That with these conditions that are included in the proposed contested case order, that this would result in the protection of health, safety, and welfare of Oregon citizens. So that is the summary. So again, we have 3 parties who filed exceptions on this issue, and they can present oral argument in the order that they choose.
Good morning. Irene Gilbert here. Knowing you're going to deny my request for exception on this based on, and you've also denied all procedural arguments, I'm going to kind of focus some on the procedural issues that relate to this particular case. This is one of many issues when the administrative law judge used procedures to hamstring the public participation in contested cases. My contested case is in regard to whether it's appropriate for council to authorize an exception and variance to the DEQ's rules. And this is one example because obviously in order to decide if you're going to be able to issue an exception, you have to know what the noise effects are. And I was denied any arguments regarding the methodology or the establishment of what the actual noise impacts are going to be, which makes it very difficult to justify an exception. And if you look at the noise issue, it's one issue, and yet you see 4. Actually, there were a couple of other noise issues, if you will, which were really just pieces of the noise problem. So anyway, when you there are a couple of court decisions. One is DLCD versus Tillamook County, which says decisions stating petitioners need not have raised individual arguments regarding my issue. So that court decision said was, you don't have to give all the details. All you have to do is raise the broad issue. And another one here says that, this is with League of Women Voters, says that individual arguments regarding an issue on appeal cannot be limited. So the fact that they have thrown out everything in my contested case on exception or variance that had to do with what the actual noise levels are and whether or not that was correctly identified is not going to hold water in appeal. Let's see, I wanted to also state that I might insert anyway, the fact that there's no deference to an agency when it comes to interpreting another agency's rules or statutes. And the statute specifically says that how the rules are supposed to be established by DEQ, and the DEQ rules have to cover specific items, and that they are, in effect, the statute. Because the statute is so clear that it says you will determine how you're going to measure it, how you're going to interpret it. It's that specific. The other thing, so I was going to talk about unusual and infrequent. Odo reinterpreted the idea about how much noise level exceedance there is. In the rules, it clearly says that when the corona noise is exceeding the ambient degradation standard, they're talking about how many days, and it specifically says any hour within a 24-hour period. If there's an exceedance of this standard. So in Union County, that means that 35 days out of every year, we could expect the weather to be such that instead of looking at it that way, what the developer did is they said, well, if we look at the amount of days, or not the amount of days, but look at it as a block of time. So if we were to have this weather pattern for 4 days in a row, then it would be just a minor event in a 365-day year. That's not what the rules say. The rules say 1 hour within any 24-hour period. If there's an exceedance, there's an exceedance. That is not infrequent.
Thanks.
So, thank you.
Any questions from council?
Excuse me, just real quickly, this is the court reporter. I just want to let you know that there's starting to be some disruption in the Wi-Fi.
Uh-oh.
Okay, thank you.
So for the record, Todd Cornett, just checking, were you able to hear the entire testimony?
Yes, it was questionable, but it did come through, but it was just kind of like a in and out, in and out.
Okay, we've turned off the video to make sure that we have the bandwidth. So again, please let us know if you have any interruptions.
Thank you, I will.
We're ready for the next.
Carl Anuda on behalf of STOP. You have several issues embedded in this particular one. One of them is the legal question of, can the department or the council take over the authority of DEQ and EQC to grant a variance? Our position is very simple. You could go to them, or the applicant could go to them and say, will you let us do this because you're no longer administering the program? And if they say, heck yeah, we're no longer doing anything, then you have authority. If you don't do that, you can't just usurp the authority of another agency and say, hey, we're going to do that stuff, because we don't think they will. So that's pretty much a straightforward legal question. We don't think you have that authority. Odo argues that you do. I think we'll ultimately end up having to see how an appellate court views that. We don't think the grant of authority is that broad. The secondary issues you have here is, does the applicant's materials and the department's analysis actually meet the requirements for a variance and or an exception? And if there is one, should it be for the entire line, or should it be based on individual NSRs where the actual high levels of noise will occur? Our position on the latter is very straightforward. You shouldn't be granting anybody an exemption for an entire facility that goes for almost 300 miles. It should be focused on the NSRs where there actually are exceedances. As to whether they meet the standard, they don't. As Ms. Gilbert just noted, that there isn't an infrequent issue here because it's 48 days if you're in Union County. That's not infrequent. There's also no special circumstances here that render compliance impractical. There are other routes where there wouldn't be this problem. One of them would be the NEPA route, but the other routes would make this perfectly feasible. There's also a exception allowed if substantial compliance would result in substantial curtailment or closing down of the business. Well, the business doesn't exist right now. So it wouldn't be closing anything down. And if the applicant can't comply with the noise standards, then they shouldn't be building the line. You shouldn't be approving things simply because the applicant can't meet your standards. You should be saying, meet the standards or your certificate is denied. That's how that's supposed to work. Then one of the other points to think about is you're obligated, if you're actually applying the DEQ noise rules, to balance the equities here, and that wasn't done. If you look at the order, the public health, welfare, and safety on noise issues were not balanced against IPCs. The only thing that was balanced was the cost and the difficulty for IPC of building a line that actually complied with the standards.
Thank you, Mr. Anuda. Are there any questions from council? Okay, thank you. So the next is Mr. Horst.
Excuse me. My name is Joe Horst. This regards to contested case in C2. OAR 340035001 regarding exceptions reads specifically, when establishing exceptions, the department shall consider the protection of health, safety, and welfare of Oregon citizens. This does not do that. There might be an argument made that this might be for the greater good of the Northwest, but the OAR specifically says health, safety, and welfare of Oregon citizens, not Idaho citizens. OAR 34003500100 regarding variances reads specifically, conditions for granting. The commission may grant specific variances from the particular requirements of any title, regulation, or order to what specific persons or class of persons shall specific noise upon such conditions as it may deem necessary to protect the public health and welfare. Well, this actually does the opposite of that. It does not protect the public health and welfare, so that therefore that does not apply. The Oregon legislature has made it very clear. ORS 467010 reads, the Legislative Assembly finds that the increasing incidence of noise emissions in this state at unreasonable levels is as much of a threat to the environmental quality of life in this state and the health of safety and welfare of the people of the state as is pollution of the air and waters of this state. The Oregon legislature takes noise pollution very seriously. While the Oregon Department of Quality no longer does the variances or exception, they did set the standards to what maximum noise levels should be. If a company wanted to pollute a river and they're guessing it's going to be 10 to 20% over what the maximum allowed is, or if a company wanted to put smoke in the air, just saying, it might be 10, might be 20. We really don't know that for sure. Over the maximum allowed, I'm sure they would be rejected. the department is, and Idaho Power is asking for exceptions that would be determined over the maximum level that the ODEQ has already, made maximum level should be. So I'm asking that that you guys reject their exceptions or variances at all. I'm just gonna make a quick comment from what I've seen this process so far. Yesterday, I made a comment that on this, that the LeGrand City Council does not want this route to be used. There's many citizens that don't want it to be used. You guys aren't listening to us. You're not listening to us at all. Mr. White came in and he was concerned about the blasting. He lives on the bottom of a huge steep hillside and he's concerned about his house. And you guys say, well, we're going to give you a week's notice, so you can get out of your house. So if the rocks come down, you're not in it. It's just wrong. You're not listening to what we're trying to say. He didn't care about the notice. He doesn't want his house flattened. While that road, my road might be 15 to 20%, it goes up at an angle. That, if you ever look at that hillside right at the bottom of those houses, it's big and it's steep. If a cement truck's coming down that road and there's another car coming the other way and it's a blind corner, either the two are going to hit or that cement truck's going to go off the road. If it does, it's going to land right on a couple of houses. There's no way it can't.
Thank you, Mr. Horst.
So, yeah, okay. I apologize. Thank you.
Any questions of Mr. Horst? Okay.
Good morning, Ackner again, for the record. The arguments that the parties have made on this issue are far-ranging, and I will try to just briefly touch on as many as I can in the time that I have. First, as Mr. Ratcliffe explained, FSEC does have express jurisdiction to assess an application for a site certificate to make sure that it complies with state statutes and rules that are normally administered by and enforced by others, including ODEQ's noise rules. And FSEC's findings regarding compliance with such statutes and rules, it is binding on those agencies. Accordingly, the council does have jurisdiction to issue a variance or exception in this case. And as we explained in our briefing, the legislature, when it adopted the noise statute, it clearly didn't intend that it would be inflexibly applied in each case because it allowed for variances and exceptions. Now, neither EQC or DEQ are currently enforcing their noise statutes and rules. So in order to give effect to the legislature's intent, FSEC is the only agency that can consider a variance or an exception in this case. So you have the ability to do so, and as a matter of policy, you should do so. And with respect to Mr. Anuta's suggestion that the applicant or ODO should have consulted with DEQ or ODO, I can tell you there's an affidavit in the record here that on another issue related to noise, the applicant did contact DEQ to try to get some advice, and we're told very clearly we don't have staff to even talk to you about this issue. That was on a different issue, not the variance or exception issue, but to give you a sense, there is evidence in the record that there is no one to talk to there about noise. So second, based on Idaho Power's noise modeling analysis, the corona noise exceedances caused by foul weather events are in fact infrequent and unusual, therefore warranting an exception to DEQ's anti-degradation standard. Idaho Power has demonstrated that on average, and applying conservative assumptions, the project will be in compliance with the noise rules approximately 98.7% of the time. And when you specifically look at the LeGrand area, which was the subject of some controversy here, B2H will be in compliance approximately 97.3% of the time. Now, both Stop B2H and Ms. Gilbert have focused on the fact that Idaho Power's analysis does show that if you look at that data on a daily basis, there will be 48 days in a year, or 13% of the days, where there will be an exceedance. But we think the sole focus on that data point it's misleading, because it treats a day in which there's an exceedance in 1 hour the same as a day where there was an exceedance in every hour. So while that's an interesting data point, we're not ignoring it. We think much more salient is to think about how many total hours of the day is there going to be an exceedant, and it's a tiny little fraction. Finally, a variance is appropriate because strict application of the noise rules, given the numerous other constraints the company needs to avoid, could render B2H unpermittable, which would deprive the region of critical infrastructure that's necessary to achieve a clean energy grid. And it's been supported and prioritized by the state and the nation. And with respect to Mr. Anuta's claim that the NEPA route wouldn't have had any of the same issues, there's absolutely no evidence in the record to suggest that there would have been no exceedances along the NEPA route. And finally, and thank you, the other parties went a little long, so if you'll indulge me, just 30 more seconds. Keep in mind also that health and welfare is one of the bases, one of the things that you have to consider when you would grant an exception or a variance. Keep in mind that corona noise that is predicted to occur will only be during foul weather, and it's most likely to cause an exceedance in nighttime hours when it's particularly quiet. Under these conditions, most residents will be indoors where sound levels will be significantly attenuated. And under foul weather conditions where the rain is heavy, then corona is frequently masked by the sound of the rain hitting the foliage. So our prediction of exceedances is really quite conservative. As Idaho Power's acoustical expert, Mr. Mark Bastash, explained, the evidence confirms that B2H won't cause exceedances of DEQ's maximal allowable sound standards for industry sources, the maximum amount, and Oregonians can reasonably be expected to hear, sleep, and go about their daily activities without interruption. Therefore, the granting of a variance and exception, together with the site conditions that we'll talk about a little bit more in a few minutes, are fully protective of Oregonians. Thank you.
Thank you, Ms. Rackner. Are there any questions from council? Councilor Condon.
So I can face you without turning. So thank you, Cindy Condon. One of the things that is concerning to me is there's certainly reliance on modeling. I certainly get that. And there are certainly comments made that people can reasonably expect this or that. So when the project is finished, if there are exceedances, what's the consequence of that? Does the public just live in your mind? Does the public just live with that? You know, yep, we've tried to protect health and welfare, or is there mitigation that can be done for that?
Let me talk a little bit about the mitigation and the complaint process. And these are required in the proposed conditions. And forgive me if I don't know which condition number is which without checking my notes. But first of all, prior to construction, Idaho Power is going to meet with each and every landowner where there is an exceedance that is predicted, and work with them to come up with a mitigation plan. And Idaho Power proposed, and the hearing officer adopted, some very specific kind of minimal requirements that the company will offer. For instance, noise attenuating windows. They make really good, strong windows that are specifically made to attenuate noise. And what the company has committed to do, and what the hearing officer is requiring us to do, is look at what's the amount of the exceedance. And the higher the exceedance, the stronger level of window that we would propose to install. For landowners who don't want, maybe they already have fantastic windows and they want something else. There's things you can do by blowing insulation into homes. If people are more concerned about the impact of noise, maybe they wouldn't be able to hear the noise because they already have like a really strong and tight house. But they're more concerned about noise in their front yard. We can plant trees, we can put in foliage. So I use the term a lot of tools in the toolkit. So there are a lot of tools in the toolkit for addressing concerns. So for those people for whom an exceedance is expected or under our analysis, before construction even occurs, we're going to go through that whole process. And as I think Jesse explained, that if there's any disagreement about whether the mitigation that we're proposing is adequate, then we come to the council and the council can decide this was good enough or this wasn't good enough, try something different. So there's a whole process and set of rights that landowners will have under that condition. Now, what about those people that we haven't predicted are going to have an exceedance, but once the line is energized, they think it's noisy and they are concerned about it? Then there is a complaint process. And again, prior to construction, there's a lot of detail in the conditions, but prior to construction, the company has to provide Odo with a detailed complaint process that that will kind of lay out what the rules are. So people can come to us, they can rely, if they want to do their own measurement, they can do their own measurement. Otherwise, we can bring in our own measurement. If there's a disagreement, again, that type of thing can be resolved by the council. But then we go, but if we find that there is actually an exceedance, that they're correct, this is loud and it's an exceedance, then we go through the whole mitigation process with those folks as well. So whether they're on our list where there's an expected exceedance or whether an unexpected exceedance is identified, there's a full suite of mitigation that we can provide.
Thank you. And just to follow up, so the number of people on your list are within the 1 mile. I think you said that there was just one more exceedance from the half mile to 1 mile.
Yeah.
But would it be the NSRs within the mile that you're assessing?
Yes. And to go back to something I said earlier, and again, there's a lot of detail, and so I hope that Kellen, you'll correct me if I get any of this detail wrong. I'm not looking at the site condition itself. But this was something that the company agreed to do. It was really in response to some concerns that Stop B2H was raising about notice, that what we agreed to do was that prior to the line being energized, we will provide notice. We're going to update X7, which was our list of all landowners within a mile. And then, so we're going to update that list because there could have been changes. Then we're going to send out notice to all those folks within the mile and tell them what their rights are. So we will have already mitigated for the people we know about, but then before the line is energized, we'll make sure that all landowners understand that if they're hearing corona noise and they are bothered by it, that they have rights under a complaint process.
Thank you.
Yes. Councillor Beyer.
Is Councillor Beyer, just for the record, variances and exceptions make me a little queasy, and I want to make sure that the department and the council are on great grounds in setting forth the parameters for issuing this exception. So that's for the department, just to make sure we feel really comfortable, because anytime you grant a variance or an exception, you're kind of setting a precedent, and it just makes me queasy. But also, Kellen, if we can, before we get done with the noise discussion, dig in a bit to the conditions because I think that would help us all be more comfortable. And thank you for going through that detail of what kind of mitigation. That makes me a lot more comfortable in terms of the overall process. Also, if you could remind me how many of these noise sensitive residences or occurrences there are currently. I can't remember.
So we, under our modeling, we predict that there are 41 residences, and I believe they are all residents. We looked at schools and hospitals as well, but I believe they're all residences, and there's 41 of them where there's a prediction of an exceedance. Now, a number of these exceedances are 1 dBA over the threshold, but there are exceedances that are, you know, I'm not going to say exactly what it is because I don't want to get it wrong, but they are significantly, you know, more significant of exceedances. They're kind of all over the map.
Chair, this is Hanlon. I'd like to go back to the issue of whether or not FSEC has the authority to grant the variance. And we have in the record evidence that DEQ responded. They had an internal management directive and they responded to STOP's discovery request that the DEQ and EQC no longer administer the noise control program and will not process requests for exceptions and variances, and local governments and FSEC may enforce the noise rules. So that's directly from DEQ. And so I think it's important to recognize that they recognize we have the authority to process the exceptions / variance requests. And then also, I believe it's under a DEQ administrative rule 340350110 states that DEQ is going to suspend their administration of the noise program and includes but not limited to processing requests for exceptions and variances. So not only do they recognize that we have the authority, they recognize they no longer have the authority. So I think that's important for us to recognize as well.
Any other questions from council of Ms. Rackner? Okay, Council Rowe.
Hanley just did my job for me. That is one of the main points I was going to make, is that there is that DEQ internal management directive that explicitly says that that FSEC staff review applications to ensure that the proposed facilities meet the state noise regulations. So contrary to Mr. Anuta's assertion, this council and the department don't need to go to DEQ or EQC to request that authorization because they've already made it explicit. Beyond that, I don't know that there's much that I can add. I will point out, and I do appreciate the question about the conditions that have been posed, and we do intend to go into those in some detail under issue NC4, and those are in the proposed contested case order as well. So when we have that discussion, we should all have those conditions in front of us so that you're comfortable that you're really understanding them.
Thank you, Council Rowe. And on my job here, keeping people to 3 minutes, I let both parties exceed that. And so I consider it even right now. But from here on, I'll be interrupting you at the 3-minute limit. So on the, I guess we're ready for the straw poll.
Mr. Vice Chair, for the record, Todd Cornett. So there's a lot of overlap between issues N2, N3, and N4.
Okay.
And so you can absolutely take a straw poll solely on this issue right now. Our recommendation is, because there is so much overlap, to wait and do a consolidated straw poll on issues NC2, NC3, NC4, as well as the standard. As Patrick kind of pointed out, under issue NC4, you're going to get into the conditions more. So again, your choice, but it's our recommendation, and the way we've set this up is to hold until the conclusion of all of the remaining noise control issues.
Okay, what's the pleasure of the council?
So this is handling, we have pulled on one, NC1. I'd like to go ahead and pull on NC2 and then consolidate 3 and 4, if we can.
That's fine.
Council good with that? Okay.
Okay, so agree with the findings of fact, conclusions of law, and conditions of approval in the proposed contested case order pertaining to issue NC2.
Sounds good.
Ann Byer,
Yes.
Perry Chalktoot,
Yes.
Cindy Condon,
Yes.
Hanley Jenkins,
Yes.
Ken Howe,
Yes.
Jordan Truitt.
Yes.
Thank you, council members.
Issue NC3 has one limited party filed exception, Stop B2H. The issue is whether the methodologies used for the noise analysis to evaluate compliance with OAR 340-35-0035 were appropriate, and whether the Oregon Department of Energy erred in approving the methodology used to evaluate compliance with that rule. The hearing officer's opinion, she first noted that the applicant identified specific locations within the 300-mile transmission line to set noise monitors and collect ambient noise monitoring data to then be used for the evaluation of predicted worst-case operational noise to evaluate whether the proposed facility would result in an increase of 10 dBA or above the ambient anti-degradation standard. In Union County, the location selected and evaluated in the application for site certificate and proposed order for baseline noise monitoring is referred to as MP-11. MP-11 is in proximity to I-84, Highway 30, and a Union Pacific Railroad. Noise measurements identified ambient noise levels at this location of 32 dBA. The applicant's expert witness, Mark Bastach, confirmed that the noise level used to evaluate compliance with the anti-ambient noise degradation standard is based on L50, which is an averaging of all total hours. Train noise, given its limited duration, would be filtered out over the sampling period. In response to issues raised by the limited parties through the contested case proceeding, the applicant introduced new noise monitoring data for 4 new monitoring position locations within Union County. These are referred to as MP 100, 101, 102, and 103. Data was collected for 3 weeks in October 2021. The applicant selected the monitoring positions to represent NSRs located closer to Morgan Lake and the La Grande Valley. Baseline data relies on the quietest times of day, midnight to 5 a.m., where wind data was recorded as calm. At these 4 new monitoring position locations, the mean L50 was 31 dBA, 36 dBA, 32 dBA, and 43 dBA respectively. The hearing officer also found that Stop B2H's introduction of monitoring data from Mr. Kerry Stanley should not be used to determine representative ambient noise levels. She concluded that the data set is too small to allow that conclusion. She also found that OAR 340-35-0035-3A expressly authorizes the reviewing agency to approve sound measurement procedures, and the department and its noise consultant, Golder Associates, appropriately vetted and concurred with the applicant's methodology. The hearing officer also considered whether the variance/exception should only apply to the NSRs where exceedances are predicted to occur today. The noise control regulations do not address the difference between a nonlinear and linear facility. The council should acknowledge the difference, i.e. there could be a situation where there are new NSRs or NSRs that were inadvertently missed in the evaluation. Granting an exception or variance for the whole line creates some flexibility for IPC to avoid an automatic violation of the standard. The conditions assure that if this were to occur, a full formal evaluation would be required. And upon a complaint filed, the same level of mitigation for known NSRs is required, which includes the opportunity for council review. So that is the summary of the hearing officer's opinion on that issue, and Stop B2H can present oral argument.
Carl Anuda presenting for Stop B2H. Hopefully you've had a chance to read the exceptions and materials on this. The crux of the dispute was over monitoring point 11 and whether it is or is not representative. Stop provided a spot check with data from Mr. Stanley that showed it was not representative. The Idaho Power did a spot check for a bit longer, but it was still nothing but a spot check that suggested it might be representative, but it may be not. Maybe it was not representative in the other way. Ultimately, the problem here is that you're trying to set, they're using monitoring point 11 to set a baseline level, and the baseline level that was chosen, which was started out at 32 and went to 31 dBA, is way higher for a rural area than any other of the rural counties. And there's a chart in the record, we cited it repeatedly in our testimony and our exceptions, that shows all the other counties have baseline dBAs between 24 and 25. That's where the dBA for Morgan Lake and Mill Creek routes should be. And we presented evidence that showed that the fundamental problem with monitoring point 11 is it's too close to the Union Pacific train line, where there are 25 to 35 trains per day that increase the ambient noise level. So that's the fundamental problem here. We urge you to remand for further analysis, or to conclude that what's really needed here is to set a baseline for Union County that's the same as the baselines for the other rural counties, which is in the 24 to 25 levels. If you do that, it's going to increase the number of NSR exceedances. But as has been pointed out, there is a process in the conditions for complaints and addressing those exceedances. And we think that process should be available to all those people that are at 25 and go up from there, rather than just all those people that are at 31 and go up from there. And I'll talk more about the conditions when we get to NC4. We made a bunch of recommendations to tighten up that language so that it really does what Idaho Power says they want to do. For now, I think what you really need to wrestle with is, do you want to have ambient noise levels set at a level way higher for Union County than all the other rural counties? And what's the safe thing to do here? We've outlined in our testimony and our exceptions why the safe thing to do is to lower the dBA for the baseline for Union County. I urge you to do so.
Thank you, Mr. Anuda. Are there any questions from council? Okay, thank you.
Again, Stop B2H's argument about Idaho Power's noise monitoring methodology is focused on the company's use of MP11 to set the average ambient sound level for NSRs in the Morgan Lake area. However, all of these arguments were completely invalidated by the company's supplemental noise monitoring in Morgan Lake area, which yielded ambient sound levels that are virtually identical to the ones at that we received at MP11. So all this focus on what's wrong with MP11 is simple misdirection. Mr. Anuda also referred to our monitoring as spot monitoring. Well, Mr. Stanley performed spot monitoring for 3 hours. Idaho Power performed monitoring round the clock for 3 weeks, which was the same monitoring protocol that was approved by ODO for all of the initial monitoring. So our supplemental monitoring was robust and lengthy and can't be fairly be called spot monitoring. Now, in response to STOP's concern, so we did do this supplemental monitoring. The monitoring point that we selected for the Morgan Lake area, which was the area of most concern, was right adjacent to the park. We chose the quietest place in the area that we could to provide the most conservative results. For MP11, Idaho Power measured an ambient sound level of 31 dBA, which is 1 dBA less than what we had found at MP11. 1 dBA, as our expert explained, it's not perceptible to the ear, but it did create, if we adopt that approach, which we agreed to do, 2 more NSRs that will be mitigated under our plan. Now, Stop B2H has taken exception to the fact that the hearing officer didn't accept the monitoring results of his own expert, Mr. Stanley, which was indeed significantly lower than what we received from MP11 or 100. But as I said, that took place in just 3.5 hours. And as pointed out by both ODO's expert and our expert, Mr. Stanley failed to follow the most basic procedures for ensuring and verifiable and reliable data. And in the end, while Mr. Stanley initially said that he had produced an ambient level for the area, he had to agree that he never really intended that. That's not really what his monitoring was intended to do. So Stop B2H also argued a list of criticisms of Idaho Power's selection of MP11 as the proxy, and I see I'm out of time and I'm going to be respectful.
Thank you, Ms. Rackner.
Yeah.
Are there any questions of Ms. Rackner? Like Councilor Jenkins?
This is Hanley. Lisa, I'm having trouble finding it, but I was pretty sure that I had read in the exceptions that Mr. Stanley admitted that his measurements, and you just alluded to that, had problems because, one, he didn't calibrate his equipment, and two, it was only for the 4 hours. Is that
So
correct?
I think Mr. Stanley did acknowledge through his attorney, there was some email back and forth, that he had not calibrated his equipment. He did something, I can't remember, it's something called like a spot check of his equipment, but didn't calibrate his equipment. His equipment also hadn't been calibrated as required under DEQ rules. You have to have it calibrated a year before you do your monitoring. That didn't happen. He didn't do a calibration in the field. I don't believe he ever admitted that that was the problem with his monitoring, but you'd have to read his testimony. He seemed more to be focused on the fact that he had to agree that since he only monitored for 3 hours, he can't possibly have claimed to have captured any representative example. And he did in his monitoring results note that it was a quiet night with no wind.
Yeah, it was
Well,
pretty-
many nights are quite windy. There's a lot of trees out in that area, which means that it's loud when it's windy. So on that, I think Mr. Stanley did acknowledge that it was just the brevity of his monitoring meant that it really couldn't be used to set any kind of a responsible level.
Thank you.
Any other questions from council? Okay, thank you.
Thank you.
Council Rowe.
Mr. Groh, Department of Justice, on behalf of the Department of Energy. A couple of comments just for context. I know that we've already discussed the noise rules, but I just want to make sure that council is understanding that there's really essentially 2 types of noise rules that DEQ has. Kellen discussed these. There's a maximum allowable noise, and there's the ambient degradation standard. No one is arguing that the proposed facility will exceed the maximum allowable noise. All we're talking about is whether it will exceed the anti-ambient degradation standard, meaning 10 dBA above background levels. So I just want to make sure that we're all understanding that. Second, with regard to the additional supplemental monitoring that was done, I also want to make sure that council is appreciating that this was done during the course of the contested case. So Idaho Power was being responsive to concerns that were raised. They weren't turning a deaf ear. They were acknowledging that legitimate concerns had been raised about the monitoring that was done at MP11 and whether or not it was representative. In response to that, during the course of the contested case, they retained their noise expert to go out and do, as Ms. Rackner just described, an additional 3 weeks of supplemental monitoring. The hearing officer held that methodologies, that IPs that Idaho Power used for the noise analysis were appropriate. The department agrees.
Any questions from council?
Ms. Hanley, my question's for Patrick. The hearings officer recommended revisions to noise condition number 1 to add the additional 2 exceedance locations. Does the department support that?
And I think there was actually a correction. There were 2 locations that Idaho Power had initially estimated exceedances at and then determined that there would not be exceedances, but then identified 2 other locations where their analysis had now projected that there would be exceedances. So the department does support the correction to the NSR numbers that are identified in the condition.
Any other questions from council?
Well, my comment would be that, that we make those amendments.
Yeah.
And you had noted that the hearing officer has included those in the proposed contested case order, correct? Okay. So we'll need to.
So, but
I want to make sure I'm on the same page as what you're discussing. So let me look at let me take a look and make sure that you and I are talking about the same thing.
Okay. So, but what you're suggesting is that they're in the contested case order, but they're not in the proposed order?
I'm referencing, yes, correct. There's a proposed amendment to the condition in the proposed contested case order that revises the list of NSRs at which there are projected exceedances. In other words, those folks that Ms. Rackner was describing earlier that have already been identified as possibly having exceedances and who will automatically be part of the mitigation process that Ms. Rackner described.
Right.
So there is a proposed amendment to those identified NSRs. That's what I'm referring to, and that is in one of the noise control conditions.
In the contested case order.
Correct, but not currently in the department's proposed order.
Right.
So that would be a change.
Yes. Okay. Thank you.
Okay, I believe we're continuing on now to NC4, and it's yours, Council Ratcliffe.
Issue NC4, the limited party is Stop BTH. The issue is whether the mitigation / proposed site conditions adequately protect the public health, safety, and welfare. The proposed contested case order, the hearing officer's opinion, the hearing officer noted that there were that the proposed order, the department's proposed order included 5 recommended conditions to minimize and mitigate potential impacts from operational corona noise at noise-sensitive receptors. Through the contested case proceedings, Stop B2H, the department, and the applicant proposed revisions to noise control conditions 1, 2, 4, and 5. The hearing officer rejected review of additional revisions to noise control conditions proposed by Stop B2H in their closing argument, but accepted revisions proposed by the department and the applicant. The reasoning was based on the fact that the department and the applicant would not have had an opportunity to review and respond. The hearing officer concluded that the amended recommended conditions posed by the department and applicant are adequate to protect public health, safety, and welfare. And so this is where, as part of the discussion, we're going to go into a bit more detail in terms of the amended recommended noise control conditions. We can see what the council wants to do with this. We can either pull those amended conditions up on the screen now before the oral argument takes place, and try to work through some of that, or we can go ahead and have the oral argument first and then have discussion on the amended conditions.
The council prefer details now or after oral testimony?
Yeah, I'm with Ann. This is Hanley. I do the testimony.
Okay.
And we've got a full package.
Okay, so we can go ahead and have Stop BTH come on up for oral argument then.
Carl Anuda appearing for Stop B2H. First, let me start off by pointing out from a background perspective, Stop submitted a series of proposed amendments to the noise control conditions to 1, 2, 3, and 4. Those are on PDF pages 38 through 48 of our exceptions. They are outlined with the proposed changes in red, and I urge you, when you get to the point of discussing conditions, pull those up and look at them, or have the department pull them up so you can see how our language actually tracks what Idaho Power claims that it is willing to do and tries to lock down the protections for the citizens of these counties that will be crossed by this massive project in a way that is functional. Basically, the initial dispute here was that the hearings officer rejected our conditions, claiming they were untimely. That is not correct in our opinion. We outlined why that was. It's my understanding from reading the responses that the department and possibly even Idaho Power, although I'm not clear on that, agree that that rejection is untimely was inappropriate and that those conditions should be considered by this council. The conditions that we proposed create a complaint process that extends out to the entire 1 mile. They create a notification requirement in advance of construction, not in advance of energizing the line after it's already built, but in advance of construction, so that everybody during the whole process knows what their rights are. We've also proposed that to some additional monitoring to verify whether the baseline levels really are accurate. In addition, we've proposed that the baseline levels be modified back down to the level they should be. Ultimately, I would urge you to look carefully at those conditions that we've proposed, because we tried hard to create a balanced, functional set of conditions, and we are convinced that the set that was proposed by the hearings officer does not go far enough in some areas. In the responses, the department and Idaho Power contended that some of our condition language was redundant of other places. It's not. We were very careful to try to cover, for example, ongoing maintenance in the noise area and technology developments in the noise control area out through the operation of the line, not just up front, because as you all know, technology changes. This line is going to be here for a minimum of 100 years and likely forever. So there should be a condition that requires ongoing monitoring and ongoing maintenance and ongoing updated technology.
Thank you, Mr. Anuda. Any questions from council? Okay.
To hear that you will be going through the proposed conditions in detail because they're long and voluminous and there's lots of little twists and turns in them. And I think I certainly couldn't cover them all in 3 minutes. And I think it's really important to understand just how robust those conditions are. And as Mr. Anuda acknowledged and Mr. Ratcliffe referred to, many of the changes to the conditions were either proposed by Odo or Idaho Power specifically to respond to Stop B2H's proposals. We agreed when we heard their concerns. There were many of those concerns that rang true for us, and we thought these are issues that we can cover. So I'm happy to hear that you will be hearing more about that. And I think it's hard to talk about Stop B2H's conditions in the abstract. And again, I don't have time to refer to each of them. I will say that I think that if you, number one, they're unnecessary to meet the standard. We disagree. We think that they are duplicative of condition requirements that the hearing officer already adopted in response to both Odo and Idaho Power's proposed changes. And we also believe that any number of them are just impractical. So for instance, I'm just going to give you an example. And if I've got this wrong, and Mr. Anuda can correct me, but I believe one of the proposals is to do ongoing monitoring during once the line has been energized. It is a 300-mile line. There just isn't a sensible monitoring approach that Idaho Power could undertake. We absolutely believe that the best way to make sure that the line is operating as it should and not impacting citizens is the complaint process. So we think the most important thing that we can do is make sure that everybody within a mile of that line gets notice that they have rights under the complaint process, clearly understand what the complaint process is, and then it will be up to Odo, the applicant, the complainant, and ultimately this council to decide what is correct and fair for each complaint.
Thank you, Ms. Rackner. Any questions from council at this time? Okay.
Thank
you. Council Rowe.
I don't have any comments, but I just have a suggestion for how we might go about doing this. And the amended condition as proposed is in the proposed contested case order conditions. So I suggest that we project that on the screen and that you also have it in front of you, because sometimes I've noticed on this screen it's difficult because it doesn't seem to capture the full content. So if you have in the proposed contested case order, if you start at page 205, and I would suggest we literally just go through it paragraph by paragraph, and we allow Mr. Anuda to come back up. And when there are sections of the proposed condition for which he has proposed an amendment or a revision, he'll be allowed to explain his position, and then Idaho Power and the department be allowed to respond.
That I have the proposed contested case order up here. I also, because this is it under in the order where the hearing officer discusses conditions, she does highlight where there are changes from post order under down here at the bottom, which Patrick, that's where you pointed us to.
Actually, I would show what had changed.
Well, I guess what I'm offering is that Sarah's provided this. So this is, and I know it initially, give it a minute
No.
here.
Kellen, can you go to page 205?
Sure.
And I think it's important that council understand the changes that have already been made compared to what was in the proposed order, because there have been significant revisions.
Just gonna shrink it. I'll keep it a little bit, but.
So we have the changes that are proposed by the hearings officer on the
Right there.
screen and in our hard copies on page 20, starting on page 205.
Correct.
We have other proposed changes by stop. Do we want to go through these and then hear what stop's suggestions are?
This is my idea, and you can handle it however you want, but were it me, I would go through paragraph by paragraph, and Mr. Anuta can identify whether or not STOP has proposed any revision to that particular paragraph. If he hasn't, then there's really nothing to consider except, do you accept what's proposed? If STOP has proposed a revision to a particular paragraph, Mr. Anuta can explain why he thinks it's necessary, and Idaho Power would be allowed to respond in the department as well.
So I guess maybe it's
Okay.
an opportunity for both to come up to the table.
Yeah.
I think that's good.
Mr. Nuda and Ms. Rackner, it might be best if both of you come up as we work through, sounds like paragraph by paragraph, these sections of the conditions. Okay, so I guess I'll start with paragraph 1, begins with prior. Are there any suggested changes from STOP on that paragraph?
Trying to get there on my computer.
Okay,
Unfortunately, my printer didn't print all of the pages, so I normally would have it in front of me. From a process standpoint, I might suggest that another way to do this would be to pull up the STOP recommended conditions, which has all the same language that you have there, and then has in red our proposed additions, because that would show you what we're actually proposing. I know what PDF page those are in our exceptions. I don't know where in your record exactly those exceptions are and which page of those you should look at to get the same ones. But for example, on that first noise control condition 1, we did propose a paragraph in advance of that. Discussion the 41 NSR property owners, and then it lists them. We suggested that it should start with prior to construction, all NSRs within 1 mile of the facility will be notified in writing that they may be impacted and that they will be informed of the mitigation process and the complaint process. And then we outlined specific notice suggestions.
So, what does council want me to project on the screen?
That's a good question.
Am I pulling up and are we looking at the proposed contested case order condition language, or am I navigating to the document? Because I'm not sure what you're looking at.
That's the,
What does council want to look at?
See these red lines.
do we want Do we want a redlined version of
Yeah.
changes that have been proposed?
I don't have that in front of me. What I have is the proposed contested case order.
Correct.
And that's
So
what
if-
I have here,
Yeah, so if we can project on the screen
the changes.
what Mr. Anuda is referring to, then at least I can compare the two.
Yeah.
D of the exceptions that stop filed.
And Kellen, is it possible to
Sorry.
do a split?
This is the court
Screen?
reporter. This is getting a little difficult because I'm not sure who's talking and there's a lot of people talking at the same time.
Crystal, for the record, Todd Cornett, I think it's fine. We're just trying to figure out the process right now. So we're trying to just figure out how we're going to display the proposed condition. So I think you're okay not covering all of this right now.
Okay, perfect. Thank you.
It is PDF page number 38.
Okay, out of the.
Out of, yes.
How can you get the stops? Should be here.
And there's some discussion of why we recommended it above, but there's the recommended stop suggested changes.
So for the record, Todd Cornett. So could somebody please articulate exactly what we're seeing? So the red text is what you're proposing to add in addition to the hearing officer's proposed condition. Is that correct?
That is correct. And this is, for the record, this is Carl Anuda. The red text you see here are the changes that STOP proposes in the condition that the hearings officers put in the proposed contested case order, where we're suggesting adding language, it's in red, where we're suggesting removing language, it's in red strikeout.
Right.
So for example, if you look at what we've proposed there as sub C, it says prior to construction, a certificate of will, and then work was struck out and initiate discussions was put in.
Okay.
So this language is what we suggested for the beginning of the noise control condition 1. And the premise here is that we want to make sure that the notice is adequate, that it goes to everyone within 1 mile, so that everybody who might be affected knows what the mitigation and the complaint process is. That's the intent of this.
All right, Carl, just before we actually get into the rationale for your proposed changes, I just want to clarify one thing. Initiate discussions is already in the proposed contested case order. That was something that Idaho Power and the department had recommended. So that's, so yeah, so I don't know that it's accurate to state that that's something that you have proposed changing.
So that was my error.
For the record, Kellen Tardy Weather, so I'm just gonna.
You don't have a mic.
For the record, Kellen Tardy Weather. So I'm just going to kind of toggle in between. I'm going to go from the proposed contested case order beginning of the condition, and then we're going to go over to the proposed condition, because as represented by Mr. Anuda, the red line should be to, anyhow, I feel like there might be items missing. For instance, the bold is 18, NSRs 118 and 132 were added. And then over here, I don't see 118 and 132. I feel like maybe we should be looking at the proposed
Yeah.
contested case order.
Like we aired when I was putting this together, we did not capture the changes. And I suspect that's because the version that I'm using here was what we submitted, and that we somehow missed that change. So because initiate discussions is in there in the proposed one.
And just,
Go ahead, Lisa.
well, what I'm wondering is, I'm a little concerned because when we were going through STOP's proposed changes, it did feel to us that a lot of, am I not using, okay, it did feel to us that a lot of them had already been addressed, maybe in different words. And I'm wondering, I'm a little concerned about what we're doing right now, which is looking at different versions of conditions, some of which the redlining may be right, some of it which the redlining might be wrong. And I'm wondering if we want to go through this and consider STOP's proposals, if we could focus on what the hearing officer adopted, and then Carl, if you could say, well, this is why we think it's inadequate. And this is the change I would propose, maybe kind of separate and apart from the redlining that you provided. We could at least start on a conceptual basis where you could say, because again, it gets to the point where we thought we covered this and it's just in different words. But if you look at it and say, no, this is the change that needs to happen in order to make it more effective, then we can have a conversation about that. Or, well, I don't know whether the council wants to have a conversation about it. Maybe you want to just talk to each other, but that feels to me like the better approach here, given where we are with lots of different pieces of paper with different redlining around.
Yeah, this is Hanley. I want to talk about what your concepts are that are different than what the hearings officer has already suggested in her draft proposed order. I don't want to go word by word here. I want to know, what concept do you feel is not captured in the hearings officer's proposed condition?
Okay. Yeah, and this is Kent, and I agree with that. I think we have the proposed contested case order on the screen, which this is, right?
Right.
Okay, that's the final document that we're wanting to know. Do we need to change or add? Mr. Anuta can tell us paragraph by paragraph if that has the language that they're hoping to have.
And then allow Lisa to respond.
Correct. Does that work? Okay, so if we start with this paragraph that we're looking at on the screen, do you have suggestions that you would like to see made to that paragraph?
Carl Anuta, yes, STOP would propose that this paragraph be expanded to cover not just the 41 NSRs listed, but all potential NSRs within 1 mile of the facility, and that there be a written notice that includes the parameters of the mitigation, what are the options, and what's the complaint process that will ultimately exist there. And we felt that the language that the hearings officer used in her first paragraph there did not capture that level of detail.
Okay, Ms. Rackner, what would be your response to that?
So this gets to a point where I was saying, we think your concern is covered in a different condition. This particular condition is specific to those landowners for whom we do predict an exceedance, and requires us to mitigate and to work on a mitigation plan with them. So it wouldn't be appropriate to address all the folks going, all the NSRs in the area for whom no exceedance is expected. But in, I believe it's condition 3, is it? Here, and I can pull up I have so many documents pulled up on my little tiny screen here. Let me see what I can find.
Got it right here.
Okay, so it is condition 2. So in condition 2, and maybe you could look at that, Carl, and see if that satisfies your concern. That requires us to create a new version of X7, which is the list in the application that includes all landowners up to 1 mile, and to send notices to those and inform the recipient that they are the owner of an NSR, and tell them about the requirements of the conditions, which include the complaint and mitigation conditions. And also let them know that prior to construction, the certificate holder will develop and submit to the department an operational noise complaint response plan. So that's the place where we proposed language, I think, that gets, Carl, to your concern.
Can I respond? I'm happy to do so.
Yes.
Okay. I didn't want to take up extra time. The, that does get some of the issue. That does not, in our view, get all of the issue, because that we added, in addition to notifying everyone within 1 mile, we added a specific paragraph that proposed the specifics of the notice and what it would cover. I think the language that the hearings officer covered was not quite as detailed, and it was more of a broad brush. And so we were trying. Apologies.
Could you maybe?
Thank you. That's the first time in many years someone's told me to speak up.
Yeah.
Hold the mic closer to you.
It's usually the opposite.
And Carl, could you, and by the way, I guess I would ask the council's permission. Do you mind hearing a conversation between us, just to try to? So Carl, would you mind pointing out what you think is missing from what the hearing officer adopted?
Let me find that section. I did not see, and perhaps I missed it in condition 2, a list of what the notice to the landowners within 1 mile would include, like the list that we included in our sub B of our proposed condition 1.
Well,
if you can point me to that.
Yeah, just look at 2A. The certificate holder will send notices to all landowners listed in the updated attachment X5, which notice shall inform the recipient that the recipient is the owner of an NSR and the requirements of noise control conditions 1 and 2. And by the way, there are stray numbers in the proposed contested case order, but I believe this means noise control conditions 1 and 2 as adopted by the council. So the noise conditions 1 and 2 talk about mitigation obligations and also talk about the complaint process.
Trying to find, so.
This is Counselor Byer. It seems as if the list that B2H is proposing of what's in the notice is a little bit more specific as to spelling out what Idaho Power has agreed to in terms of mitigation. And I think I think as stated, the information is there. It's just not as specific as what B2H is proposing for notice language to the expanded list of, help me on the acronym, but NSRs. So it's whether or not I think the council and the department feel like we need that next granular level of information in this condition. The only thing that I don't see aligning is the details of the mitigation information that would be required in the condition. I think the complaint process is clearly outlined in condition 2. So that information is there, though not necessarily in the particulars of a notice requirement. Excuse me if I'm misinterpreting.
No, I don't think you're misinterpreting, but I would like just to direct your attention, Councilmember Byer, to subsection C of amended noise control condition 1, which talks about what Idaho Power will propose, and also is specific to any folks. Again, this was in response to something Stop B2H brought up, was that if there is someone who has a health condition that they believe would be exacerbated by sound levels, then they can request a much more robust, even a much more robust set of mitigation. So I think it's in there because I think it's everything that we that we were ordered to do and required to do and we offered to do. I believe it's all in there. And I do wonder if maybe one of the ways to address Mr. Anuda's concerns is that if the full set of conditions just gets provided to the landowners, so every landowner can just look through and say, this is everything Idaho Power's required to do. You have rights, you can take advantage of them.
If I might make a suggestion, I've got an idea there, but go ahead.
For the
Council.
record, I'm comfortable with that approach. I think that we implement the conditions and need to enforce them, and having the public know what those conditions are should be helpful.
And before you respond, I just want to say one more thing, which is that given where we are in the process, particularly where we're thinking about making changes to wording on the fly, as a lawyer, that makes me a little nervous. And so I think the best way to make sure everybody knows exactly what their rights are is to give them the full set of robust conditions, as opposed to us now trying to revise the conditions themselves and to try to provide some different notice. I do have one other alternative that I think we have out there, which is that if the council is not comfortable with just providing the full list of conditions to each landowner, we could have an agreement that we will work with Odo as to a different notice. Again, I just feel like we're safer, though, just going with those conditions.
Council Ratcliffe.
Yeah, so one thing I just want to point out here is that if memory serves, and I think Kellen, maybe perhaps you could correct me if I'm wrong, but I think we have one change to a condition that has already been accepted by the council through the straw poll. We have another one that is on the table still that we're planning to do, at the end of this process, related to the blasting notice. And my recommendation again is that changes to conditions constitute material changes that require a material change hearing before we get to final order on this. So if that alleviates any concerns here about, having a chance to wordsmith conditions and make sure that the, department staff and I have not made errors in trying to translate, there will be an opportunity to comment on the changes to conditions that get made before this gets to a final order.
Thank you.
And since I've been sitting here trying to bite my lip, if you don't mind, I have a number of different thoughts on the process issue. My suggestion would be you listen to Stop's reasons for wanting a change to the existing order and what we're suggesting, and you can go work with the department or suggest that the department look at our changes, or Ms. Rackner's suggested change now of providing all the conditions, and then come up with a proposed final order that will then go out to hearing or a change hearing, if, as Mr. Ratcliffe calls it. From a substantive standpoint, the difference between what we proposed and what Ms. Rackner is proposing is that most people, when they get in the mail a list of conditions that's written in legalese, are going to go, what? What does that mean? So what we were proposing was a notice to people that they had some rights. Here's the outline of what those rights are, and here's the processes that are available. And that was the intent of our changes to condition 1, which we were trying to get at the entirety of the folks. And as I read condition 2, it doesn't necessarily require that kind of notice to everybody in that kind of notice being the kind we proposed of here's your rights outlined in a simplistic form, and here's where you can find more information. That does not appear as I saw it in condition 2. Instead, it focuses in on the process and the plan, and that's great and sets out those things, but it didn't provide the notice, and that's why we proposed the language at the beginning of condition 1.
Okay. I think we've,
Hear from Patrick.
good idea.
We
I don't
have filed a,
condition 2 that way.
Yeah. I'm sorry, Hanley, you don't read condition 2 in what way?
Condition 2 does require that you go back to condition 1.
That's the way I read it. I mean, this condition was, as Ms. Rackner pointed out, put in response to concerns raised by STOP. I read the condition as, I mean, the plain language of it says, certificate holder, not the department. The department does not want to get into the business of sending these notices. That's on Idaho Power.
We all agree on that.
Certificate holder will send the notices to the landowners in the attachment. Ms. Rackner indicated that attachment is landowners within 1 mile. That notice shall tell those folks you own a noise sensitive receptor and what the requirements of noise control conditions 1 and 2 are. Now, I agree it's not clear how they will tell the landowners what the requirements of those conditions are. So what council needs to determine is are you satisfied with this? Is it appropriate, as Ms. Rackner suggested, to provide them the language of the condition? Or do you want to do something that Mr. Anuta has suggested? Or potentially both, and have kind of a easy to understand summary of it.
Yeah, I think that's what we want to pose to the council right now to move forward. So, Councilor Condon.
Cindy Condon, I would prefer both. I mean, there are people who I think Mr. Anuta is correct, can get lost in the conditions themselves, and a list would be appropriate. There are others that would want to say, where did this list come from, and dive deeper. And so I would prefer we have notice in plain language for the public to clearly understand, plus the condition.
STOP would certainly agree with that.
Councilor
No harm in
Jenkins.
more information.
Jenkins, I don't have a problem with that. I don't know how Todd's going to reflect that, but.
Okay. Sounds like we got somewhere right then. Okay.
Cindy Condon, I'm not clear on all the exhibits, and I just want to make sure that attachment X7, what's the title of X7? Does it include everyone within 1 mile? Is that the?
Yes, everyone within 1 mile, and it needs to be updated because it is old and a few things have changed over time.
Right. And just to follow up, to distinguish between X4 and 5 that are referred to in condition 1, those are the identified NSRs.
Yes, and exceedances. Yes, or it may not just be exceedances, but actual, I believe.
I just want to understand the difference.
Yeah. Yeah, those are the folks for whom exceedances.
Oh, yeah. Okay. Thank you.
Okay, so we've got, have we dealt with condition 1 or just the first paragraph?
STOP did have a few other additional proposed changes to condition 1.
Okay.
And those would be in paragraph, what was in exhibit 1, in condition 1, the first paragraph, the second paragraph. We had suggested adding language in what was, I think, sub B, if I'm reading it right. Can we
Ms.
could
Tardy,
go
whether,
back to
we're on condition one.
yeah, condition one.
I'll be back.
Yeah, B.
Right there.
There we go. We had suggested adding some language in the about 6-7 lines down. There's a sentence that says, if this review is deferred to the department, Stop had suggested adding language to clarify that appeals from the department would be taken to FSEC. That's sort of implicit in your rules as I read them, but we wanted it to be clear in the material that, and the condition that it would go to FSEC ultimately. And that if you look at the lines up there, it's the, where it says, if this sentence on the left side, that the line that starts with review to the department, we suggested that the words appeals would be taken to FSEC be added after that to make it clear in the condition that any appeal would go to FSEC ultimately. Next one down. That review of the department.
Patrick Road, DOJ, I guess I'm not quite following that because the way it's set up is that the dispute does go to the council unless the council chair decides we don't want to handle this one, we're going to defer it to the
Right.
department.
That's the way I read that.
All right.
I'm sorry.
Counselor Byer, the default assumption is that any dispute comes to the council. If the council made a decision to direct the department to weigh on it, that's separate, but the default assumption is any dispute comes directly to the council.
That is the intention, and that's the way I read this language. So,
Yeah.
Carl, what?
Our concern was it actually says that the council chair can defer the dispute to the department, not the council. And we wanted the council to have the last word rather than just saying, oh, well, there's a dispute, it goes, and then the council chair, for some reason, I'm sure that probably wouldn't happen, but if they did, just defer it. And the rest of the council's going, wait, we want to hear that one.
I follow you there. And Todd may want to weigh on this some more. The intention of that is because council has a ton of business and we don't have any sense right now of how many of these types of disputes might get referred to the council. Council chair coordinates with the department prior to every month's meeting as to the agenda for that meeting. So if in a particular month there's a dozen of these disputes and council already has a lot of business on that month's agenda, the council chair has the discretion to decide, would have the discretion to refer that. If those 12 disputes automatically go to the council, then the idea of trying to be efficient with that month's council meeting is lost because now the 12 disputes are already in front of the council. That was the intention behind that. So do you understand why it says council chair rather than council?
And we understood, we were uncomfortable with just having the chair do the deferral, and Stop is also uncomfortable with the idea that if there was a deferral and the department says, oh, here's our decision, there should still be an appeal back to the council ultimately. That was the Stop's position, so that the council should be the last word.
Okay.
The department's comfortable with this provision, so now it's clearly in your hands, council. And I don't know, Ms. Ragnar, if you have anything you'd like to add.
No, not at all.
Okay, where's the council on the suggestion?
Well, this is Hanley, and usually in the situations where the council chair makes a decision, it's referred to the next council meeting as an information item where that has happened. So, if we have an issue, it's probably going to come up within the next council meeting. So I'm comfortable with this language. I'm not concerned that the council chair is going to abuse that opportunity.
Others?
Cindy Condon, I guess I do have a bit of concern that so there's no appeal. If the department makes a decision, reviews and makes a decision, so there's no right to come back to the council. Am I, as I read it? Once it's been deferred to the department, we have now washed our hands of it. I mean, with no opportunity to voice as a council?
The way the condition is written, yes. But again, the default is to the council. This is only in a situation where the council chair determines that for these disputes or this particular meeting, we're going to have the department handle it. The assumption is it's going to the council.
Yeah. It's difficult, I guess, for me, I mean, with the current chair, I wouldn't have any issues, but we're making the decision. This is a long-term decision. I guess I do have concern about that.
The record, Todd Cornett, just from a practical standpoint, council also sets policy. So if in some circumstances, the council chair did defer that to staff and there was no appeal rights, but then and as Councilmember Jenkins indicated, in my secretary report at the following council meeting, I would provide that update. And if council was uncomfortable with that, you would set the policy to say, we do not want to have any of these done by staff. We want all of these done by council. So there is a check in there. Council has that, as a body, has that authority to put a check on the council chair if you believe that is being abused for whatever reason.
Okay, so to try to keep us moving on, does the council feel we need to make any changes to that language? No? Okay. Okay, and Councilor Chalktooth.
Yes.
You're okay with it?
Yes.
Okay, so I think we can move on. We have a majority of the council is okay with that language. So the next, what do we do? Did that take care of condition one completely?
This is Mr. Nuda. That takes care of the stop recommendations for condition one.
Okay, let's go to condition two.
Okay.
And your suggestion on the first paragraph, are there any?
Find my version. It's not the same language.
For the record, Kalantari-Weather, I have a clarification question. So, Mr. Nuda, you were proposing that the notice language in front of condition one, but the notice language is actually in condition two. So are we addressing having the notice conversation in the context of potentially changing condition two? Are you comfortable with that, Mr. Nuda? Because then basically we aren't trying to add the notice portion to condition one.
Whether you add it to one or two, as long as it's there. If it fits better here, that's fine. But the more detailed, and actually I'm more comfortable with what Mr. Rose suggested, sending both a notice that has the kind of summary that we suggested, and then actually the conditions, and putting that here.
Mr. Vice Chair, for the record, Todd Cornett. So whether it goes in condition one or condition two, I think we can evaluate. And as Jesse indicated, that would be a material change. The language that I have, and this is not actual language because we'd have to clarify this and fit it in. But as I sort of noted it, notice will include both an easy to understand plain language summary as well as their rights with respect of their rights with respect to the noise control conditions as well as the noise control conditions themselves. So the full sort of spectrum is what I have reflected. Again, whether it's in condition 2A or in 1, we can kind of look to see where it might be the most appropriate. So if that satisfies everybody.
Yeah.
That works for stop.
Okay, that works then. Was there anything else in condition 2, or do we need to go
Not
paragraph by
conditional.
paragraph?
I'm not finding it on my screen, but I don't think plan. Yeah, I'm sorry. So specify where. Trying to find where in my version. There we go.
So with respect to that issue, I guess I would ask if Lisa or Patrick have any comments.
On where the change should be made, which condition?
Combine the two on
In condition 2.
Todd's proposal.
Oh, we're fine with Todd's proposal, but we would say that the language belongs in condition 2 and not condition 1.
Patrick?
Condition 2 that currently talks about notices, so it seemed like it would fit better there. Yeah, 2A.
Thank you, Counselor Jenkins. I
That's okay.
was moving too fast there. Sorry.
Try to get the.
Okay, so on condition 2, the remainder of it,
I don't remember. I don't see any issues with paragraph B. I believe we had some language at the end of, let's see. So yeah, it was. I think okay, so my language is confusing me because it's not in the right place, but I know what we were intending. Our intent here was to try and make sure that in addition to the plan outlining all those stuff and providing the information that will specifies what needed to be done to file a complaint, we wanted to make sure that the materials outline the process for reaching a resolution of that complaint. I think with the changes that you've suggested to part 2A, that actually covers it because it outlines all of it with the conditions. So I think that there's nothing there that needs to be there in addition. And I'm looking down, I think it wasn't until, I think it was E2 sub 3 that we had another change that we were proposing. And that was a bigger issue. That was down in the section that talked about identifying the process for a noise complaint. And there were 3 subparts. Colin, if you could scroll down to sub E, I think it is. There we go. There's subpart 1, there's subpart 2, and then in subpart 3, it said that it talks about how if they were not included in the area in X5, the certificate holder shall, make sure I remember, model the sound levels. And we suggested adding model and monitor the sound levels because our stop was concerned that just modeling the sound levels wouldn't necessarily give you an accurate answer as to what was going on and what should happen. You needed to also monitor them. So our suggestion was to add and monitor there, wherever in the sentence is appropriate.
Ms.
So-
Rack. Okay, Counselor
This is Hanley.
Jenkins.
Are you suggesting sample or what do you mean by model? Is that long-term model, monitor? Do you mean long-term monitoring or just simply do a sample?
We were suggesting monitoring of some sort. We had not defined how long that monitoring would take place, but presumably since what you're trying to get at here is what's going on with this particular NSR, you would need at least enough monitoring to have some sense of what's the noise levels over some period of time. We did not specify a period of time. Our intent was not to make it permanent monitoring. It was monitoring to figure it out. Okay, what's the issue here? And then how can we fix it down the road? Because this process is all for figuring out, okay, what do we do about those people that we didn't have on the list as expected NSRs?
So from our point of view, this could become completely burdensome and difficult to do what Mr. Anuda is suggesting. We have modeling that should show whether or not there's an exceedance. If the complainant is concerned about the result of that modeling, then the complainant can do their own monitoring and provide that to Idaho Power to at least substantiate that there is an issue there. So, our concern is, again, we have a 300-mile line and a lot of NSRs. And while we certainly respect that nobody will bring a complaint unless they honestly believe that there's been an exceedance, we also anticipate that a lot of people who hear corona may assume there's an exceedance, and we may get a lot of complaints. Modeling the kind of monitoring that's responsible takes thousands of dollars for each monitoring position, and that's probably an underestimate. You're the Idaho Power pays the bill, so I don't know. So our concern is that it could become just completely infeasible if in every case somebody hears corona and has this concern. They're able then to shift the burden over to Idaho Power to do comprehensive modeling. And I will say that kind of the spot check idea, I mean, our acoustical engineers just couldn't get behind the idea that you could set a responsible ambient based on going out for an hour. So we don't know that that's going to be a solution to try to do something quick and easy there. Now, if the complainant does some monitoring on their own, whatever it is, I mean, there's all kinds of levels of monitoring. Idaho Power performs kind of expensive state-of-the-art monitoring, but there's a lot of ways to do less expensive monitoring. If the complainant does some monitoring, even if it's quick and dirty, that demonstrates an exceedance that hasn't been addressed, Idaho Power at that point, could decide, okay, we're going to do some of our own monitoring, maybe probably longer term, probably more state-of-the-art equipment. But at least it doesn't shift in every single instance over to Idaho Power the responsibility to do very expensive noise monitoring. So that's our concern about it.
And if I might point out, this is a policy issue for the council, because shifting the burden is precisely what STOP is looking for here. We think the burden should be on the billion-dollar utility who's building the line to monitor in some fashion whether there's a problem or not. It should not be on the landowner who doesn't have the thousands of dollars to do, as Ms. Rackner described, the monitoring. So that sort of shifting of the burden was precisely what STOP was trying to do with this suggested language.
Comments from council? Oh,
Patrick Rodeo. Oh, okay. I'll quickly make my comment, and then Councilor Condon has a question. As Ms. Rackner pointed out, they could do, quote unquote, down and dirty monitoring, which is, I can't say I've personal experience with these, but I understand there are simple phone apps that do noise monitoring. Idaho Power could then come out and do more sophisticated monitoring, and then that dispute would be presented to the council for resolution. So,
and I will just say that is what we had in mind, that something quick and easy that anybody with a smartphone could do.
Okay, that being the case, then where's the council on the language? Does it achieve what we've just kind of been discussing?
So let me make sure I understand who we're dealing with here. These are the people that have not been identified through the prior modeling process as having a noise impact
Right.
facility. So what this condition proposes is that there be additional modeling done by Idaho Power. And then if the landowner still has an issue, they can provide evidence, and then it comes to us or the chair. I don't have a problem with that process.
Where's the rest of the council?
So I think I was sort of hung up on sub-issue 3, but what happens next is pretty clearly outlined in subsections 4 and 5 that says, if there's alternative data, here's the responsibility of IPC and ultimately the council. So I'm comfortable with the language.
I'm seeing head nods. Do you need to say something, Councilor Condon?
Yeah, I had indicated I had a question, and actually I was just going to make the same comment that Mr. Rowe made, but wanted to verify that was true. I mean, I think there is a phone app, I think I've used it, that measures decibels. And that if that's enough, if that is what Idaho Power would accept, then hopefully the people impacted would know that that's a measure. I think if the public reads monitoring or whatever, they might think, oh my gosh, I have to, buy monitoring equipment, whatever. I just think the public should be made aware this is what we'll accept. So, because we're, or at least I'm thinking, given this conversation, that that's acceptable. A phone app or something less than.
Yeah. And I will say, because I don't have a lot of personal experience with what all the options are out there, I really can't say in this but that maybe it's the monitoring methodology of the complainant's choice, or which may include, I don't know. Yeah, we're a little bit trying to do this in real time, but we are certainly comfortable. That was the idea, that our modeling that we did, to our mind, not that this is legally the case, but kind of created this rebuttable presumption that there wasn't no exceedance at this NSR. But if the person at the NSR is able to show in any way, like, no, we really think that the ambient anti-degradation standard has been exceeded by more than 10 dBA, whether it's a cell phone monitoring, then it would be incumbent upon Idaho Power to present its own monitoring data. And if there's a dispute, then again, hopefully they can resolve it. A lot of disputes can be resolved, but ultimately it could come to the council to look at the data presented by the complainant versus what Idaho Power brings.
Thank you.
Okay, I think we've reached agreement then on condition 2.
Mr. Nude, I think there may be one of your proposals that you haven't pointed out to council, and that goes with regard to a revision to condition 2A. You had made a proposal about submitting the Idaho Power will outline a complaint plan, and I believe you had made a proposal that that be submitted to the department for approval, and once approval is obtained, distributed to all NSR properties within 1 mile. So if you, I just wanted to point that out if you wanted to discuss that with council.
We thought that made sense. I don't know if Idaho Power objects to that at all.
I don't know that we object to that. I think we felt in our briefing that it was a little redundant because the conditions themselves are going to explain that there's a complaint process through Odo and they can contact Odo. But I don't know that we have an objection to the details of the complaint process going out to everybody so that they have it in the first place.
Okay, good. And then Councilor Condon had a question on C. Oh,
Off that, is that an instruction from council that you would like this condition to state that the complaint plan will be distributed to the NSR property owners?
yes.
And again, that's the same list and I'm just saying that as we write it up, that would be the same list of the X7 that will have been updated.
Yes, that's the way I'm seeing it.
Do I see head nods? Yep. Okay, yes. And then Councilor Condon, you had a question on C.
Yes, Cindy Condon. On condition 2C, I just want to be clear. In the fourth line from the bottom, it reads, I'll read the added language in C, and will specify the information that the complainant, so this is the NSR, right? The complainant must include in its complaint, including the date of the certificate holder received the complaint, the nature of the complaint, weather conditions of the date for which the complaint is based, including wind speed, temperature, relative humidity, and precipitation. So we're expecting that the public will collect all that information with their home weather center to, I mean, is that the
we thought a smartphone app. I've got that all on my phone, but
and could be, I'm just wondering if at the moment I don't have my complaint procedure in front of me. I've missed the day. It's the next day. So I mean, I guess looking up, I don't know how you get wind speed for 10 o'clock in the morning 2 days earlier. I just want to make sure it's reasonable, as opposed to making it a little bit too detailed or more detailed than it needs to be.
I believe this was department language, so maybe better responded to by Kellen or Patrick.
I honestly can't remember if it was department language or not. I know we were discussing this quite a bit. I understand the concern, and I can't tell you if that type of information is available just through the app. If you're concerned about the rationale for it is because those are the factors that have an impact on noise. That's the idea behind it. I suppose you could, rather than make it mandatory, you could make it a suggestion. And then if they don't have that information, but then Idaho Power is able to pull that information from whatever sources they have, then when the dispute is presented to council, there's potentially more evidence favoring Idaho Power's analysis. But so I think at a minimum, we should let folks know these are the types of things that you ought to be thinking about collecting. If you don't want to make it mandatory, I would be all right with that.
Yeah, I believe we would too, because I also thought that this was the type of information you could usually look up for any one day on the internet as well. Now, I know not everybody has internet access, but
or knows how to operate a smartphone sufficient to gather all that data.
Yeah.
For whatever it's worth, STOP would suggest, this was not one we had picked up on before, but since Councilor Condon has flagged it, that you simply modify this to say, including if complainant has available the wind speed. That gives them both the information about what kind of things you're looking for, but makes it optional rather than mandatory.
Jordan Truitt, for the record. I'm wondering if in the notification that a brief description of how and where some of this information could be accessed to somebody who may not know how to look up on NOAA's website what the previous 24-hour conditions were, just a brief tutorial on how to collect some of the parameters as much as possible. Because you still, if there's a complaint, I believe you still have to quantify the complaint with relative data that has to support your complaint. If it's just, it was loud last night, how do you support that? And so I do recognize that is for many difficult information to gather, but if there's a starting point on how to get there, that might help.
This is handling what I would suggest there is just simply saying such as including wind speed, temperature. You know,
I believe that's the easiest. I think the most important thing would be for the to know the date and the time that the person believes they experienced the exceedance, because then at that point, Idaho Power or the council can go back and try to and perhaps discern what was happening in that location at that evening.
Okay. It sounds like we have some council direction on that one. All in agreement. Such as language being added.
Thank you.
And I'd like to make a request for a 5-minute break.
Yeah.
If we could.
Yeah, I was just trying to get us to, we're done with condition 2.
We did have some additional language further on down in subpart 5.
Okay, let's
the
go ahead
E.
and take a break now and we'll come back.
I'm okay with
You are?
finishing up the condition.
let's-
I was just observing that it was almost 3 hours and.
Yeah.
Thank you.
Yeah.
Okay. Subsection 5.
Subsection 5 of subpart E. And so further down, Kellen, if you're in E, there should be a 5. No, you're down, you're in F. So there we go. This was a discussion of what happens if there's a dispute. And this was the same issue that we raised earlier. We had suggested at the end of this that you clarify that the FSEC chair may direct the department to make the determination. We had suggested adding language at the end of that. But if there has been a delegation, the department decision can still be appealed to FSEC. And that goes back to Stop's point of we didn't want the department to be the final decision maker. And your earlier discussion may be sufficient for that issue, but I wanted to flag that we wanted to clarify there as well, that ultimately, even if there is a deferral, it should come back to the council because that's the ultimate last word.
Council Rowe, that language that you referred to before, I think clarified that it comes to council.
Well, the default is to council.
Right.
Right. So the issue here is similar to the prior one, which is if the chair is going to direct the department to make the determination, that the chair in his or her discretion has determined that coming month's business, they would prefer that the department make the determination. So to me, I don't understand what the point of the deferral to the department would be if ultimately it's coming back to the council anyhow. If the idea behind referring it to the department is efficiency of council meetings, it's still going to end up before the council under Mr. Anuta's proposal.
Right. So, Mr. Anuta.
Mr. Rowe is absolutely correct. Our approach is to say it needs to ultimately go to council, even if it's been deferred to the department. That may take care of some of the process. Some people who get deferred and have the department make a decision may be fine with that. But if somebody ultimately wants a council ruling on their complaint, they ought to be able to appeal a department decision on a deferral back to the council to really get a council vote on it. That's from a policy perspective for STOP, the council should be the last word rather than the council chair making an executive decision, which may be from an efficiency standpoint, totally appropriate. But from a standpoint of policy, we wanted the commission to be the final backstop regardless.
Okay, where's the council on this one? Where we ended up on condition one?
Support where we ended up on condition one. This is Hanley.
Okay, I'm seeing head nods.
I would not be in favor. I wasn't in favor.
Okay, Counselor Choctot.
Yes.
Okay, I think we've got majority on that one to leave it like it was understood in condition one. Okay, I think we'll take a 10-minute break. Come back at 11:05.
This is the court report. I just want to make sure that you guys aren't started yet.
This and get a mutually agreed upon plan, because that gives them incentive to say, as soon
to the site certificate and the timelines in the site certificate for responding and working with landowners, because if they don't do what's required by the site certificate, they will be out of compliance with the site certificate and subject to enforcement. But it makes no sense to place them in that
Can anyone hear me? This is the court reporter.
Yeah, I can hear you. They're fading in and out.
Yeah, okay. And I don't
The
think
record
they,
is very choppy.
okay, hold on. Yeah, I don't think they're hearing us and they've started. So hold on. I'm gonna try and send them a text message.
Okay.
Crystal?
They're not hearing us.
Hello? Hello?
Can you hear us? Crystal?
Now I can, but for, if you guys started at 11:05, we haven't heard anything except maybe some Ms. Rackner in the middle of her talking. So just let you know.
Included a determination that if they reach this point in the process, the applicant will be considered to be in violation of the site certificate and subject to enforcement until they work out with the NSR property owner a mutually agreed upon mitigation plan in order to create incentive for the applicant to work out that plan.
Okay, Ms. Rackner.
And so we just disagree. We have obligations under the site certificates. If we don't follow the very detailed requirements for what we do in response to a complaint, then we could be found in violation of the site certificate. But to suggest that any complaint, meritorious or not, somehow places us out of compliance makes virtually no sense. It also gives an enormous amount of inappropriate, undeserved leverage to a landowner, just as Mr. Anuda is suggesting. What if there's someone that could be unreasonable at Idaho Power working on this issue? It's equally possible that there could be a landowner that could also be unreasonable. Those things can happen, which is why you have rules that everybody has to follow, and if they follow the rules, they're in compliance.
And if I could respond briefly on the point, this part of the process is after it has been determined that there is a corona noise issue that exceeds the standard. This is after that. It's not just a complaint and then they're working it out. This is further down in the plan where it says that if it is determined pursuant to the process described above, that this condition that corona noise at the complainant's property exceeds the standard. So this is where there's already been Idaho Power and or the complainant working together. They've figured out there is an exceedance. STOP's position is there needs to be an incentive at that point for Idaho Power to work things out. The process that Ms. Rackner is describing would require the complainant, who's already been found to have a problem, to come to the council and ask that the council find that there's a violation of the site certificate because Idaho Power won't work with them to get a mutually agreeable agreement. Our suggestion is put the burden on the applicant and say, okay, either reach an agreement or you are in violation automatically.
Ms. Rackner?
Well, I'd also like to point out that if we can't reach an agreement, then there's another process, and that process is coming to the council. So if, let's say you have an actual exceedance, but let's say you have a landowner that is saying, that is asking for something that seems completely out of proportion and inappropriate, so the parties cannot come to an agreement, then that's why we are able to come to the council. The council at that point can tell Idaho Power, either do what the landowner is asking you to do, or tell the landowner that feels like an overreach. Here's instead what we think should happen. But there's just no reason to be holding Idaho Power in some out of compliance until we've gone through the process. And as long as Idaho Power is faithful to the process, abides by council rules and determinations, they should be seen to be in compliance.
Okay, council. You've heard both sides. Do we feel there's language change needed here or not? Councillor Condon?
Cindy Condon, and I might be reading this incorrectly, but so how does Idaho Power read this provision if there isn't a mutually? I'm not reading that there's a return to count, that what happens if. So what you're proposing is that they're not in violation of the certificate. So then what? What would
Councillor Condon, this is Patrick Rowe, Department of Justice. Go down to sub 3.
Yes.
So it's
Okay.
F sub 3. That outlines the process Ms. Rackner just referred to.
But doesn't that start with if through the efforts described above, the certificate holder executes an agreement with the NSR?
Going down, the next sentence says, if an agreement can't be reached.
Oh, maybe okay. Apologies. Yes, thank you.
They're long and complicated.
Sorry.
They loop back on themselves. I totally get it.
Okay, so back to the council. Are we feeling there's any language change needed or not?
I think it's covered. I don't think it's appropriate to find someone in violation if it's still being disputed.
Right.
Agreed.
Okay. Councillor Chalktoot?
Yes.
Okay, we've got that one done. Now, do we move to condition 3 or we're,
I'm looking to see, I don't see any other changes that we proposed that we didn't already address. And 2. We did suggest language further on down in sub 3 that would suggest that the council remain the appellate body, but this is the same issue that you have discussed before as to whether or not there should be a deferral by the chair as an option. It's top position that the council should remain the appellate body, even if there's a deferral. There are no other suggested changes to condition 2 from stop.
let's move on to condition 3 then. First paragraph.
There are a number of specific changes that stop recommended to the first paragraph of condition 3. And conceptually, they all focus on the same thing. Stop's position is there should be long-term inspection, monitoring, and maintenance for the entire operational life of the project. And that we suggested some specific things that should be done to protect the lines and in terms of maintenance. And we suggested language that would require the certificate holder to monitor and inspect the line over time, and that the inspections of that sort would take place on the schedule that aligns with the OPUC utility wildfire plans, or more frequently if the department felt they were needed to be more frequent, and that when Idaho Power completes an inspection and monitoring of the line, that they should do a monitoring and maintenance report and submit it to the department so that the department can track where things are going. And then finally, that the certificate holder is required to upgrade and apply new technologies as they become available to mitigate corona noise issues. Stop's point there was that we don't know what future technology in terms of noise mitigation might be for corona noise, but if there is additional technology that comes into existence, that Idaho Power should be required to stay current on that and to apply those upgraded technologies. Maybe there'll be a new type of conductor that will help reduce noise, or a new type of metal or tower or something. We were just trying to get at the idea that for the life of the project, you got to stay on top of the technology and apply upgraded technology to help reduce corona noise for the people being affected by the project.
For the record, Kellen Tardyweather here. I've got it pulled up on the screen. It took me a minute just to kind of orient. I want to orient council of where we're at. So in front and on the screen, I have the amended condition language that Mr. Anuda just verbally presented with his rationale and the edits. Now, just to help council, in the proposed contested case order, the hearing officer discusses these revisions and the Department Idaho Power's responses, and ultimately she declines to adopt these revisions. So in your proposed contested case order, there's noise condition 3 isn't there. So your noise condition 3, as it stands now, according to the PCCO, is what it says in the proposed order. Give me a minute. There's a delay here. So, and I'll pull, so this is the condition as it stands. So I don't know if council wants to take a minute to, I'll let Jesse or Patrick to read what the, oh, okay. So here's Mr. Anuda's, and then the hearing officer provides her basis and rationale under her discussion of condition 3. Oh, can I, well, I'm going to slowly scroll through. but-
Oh, I'm sorry. Okay.
No, well, yeah.
Didn't know.
It's up to
Someone
the
let me
council.
know when it's time for me
It's
to
okay.
respond.
Yeah.
So Mr. Anuda, is this what you were working off of?
Correct. That's what the
Okay.
red language there is what STOP proposed
Okay.
as changes to 3. And I think Ms. Rackner probably has some responses to those,
Yes, I'm ready.
conceptually, if not specifically.
Yeah. So what's been proposed here is pretty completely impractical. We have a 300-mile transmission line. It will get bird feces on it at times. The idea that Idaho Power would immediately need to clean off that bird feces does not make a lot of sense. Similarly, we have a 300-mile transmission line. Now, it seems completely hypothetical to me, but even if there were some type of new conductor that could reduce corona noise, it would be at least hundreds of millions of dollars for us to reconductor this line just to buy the conductor itself, let alone string a new conductor. For those, and I do want to say one thing, is that yes, the company has to, on a regular basis, it has to maintain the line, it has to be trimming vegetation, it needs to be out there, making sure the line is in good working order. We also have the situation where we don't know if anyone is going to be bothered by the noise on this line at this point. Lots of people live near high voltage transmission lines and are not bothered at all. I'm not saying there won't be anyone. There may be legitimate complaints, but we don't know. That's very hypothetical. Given the extreme expense of the type of monitoring or technological upgrades that Mr. Anuda is referring to, and given the chance that we don't really know how the public is going to perceive the corona noise on this line, it just makes perfect sense to do this on a complaint basis. If a human being or group of human beings are bothered by the noise on the line, then that is something Idaho Power needs to address. If there's a nick in the line that's causing corona, that is something Idaho Power needs to address. If its modeling was wrong, such that there's an exceedance where we didn't think there was going to be one, that's something Idaho Power needs to address. Just the sheer reality of what it's like to build and maintain a 300-mile, 500 kV line suggests that the complaint approach is a human being bothered. Let's fix that, that's the best way to deal with this.
And STOP and Idaho Power have a clear policy difference on that. We think that the utilities should be regularly maintaining, we're not suggesting daily, but they need to be regularly maintaining, monitoring, and upgrading.
Okay, counsel.
If I may, Patrick Rowe,
Yeah.
Department of Justice, I would also point out that there is another recommended site certificate condition, and the hearing officer pointed this out in her ruling on this, her analysis of this proposed condition, that recommended organizational expertise condition 1 addresses transmission maintenance inspection plan and requires Idaho Power to inspect, monitor, and maintain the facility. That, coupled with the complaint process that Ms. Rackner has, that we've been discussing, the department is comfortable with this condition as is.
Yeah, this is, Mr. Chair, this is Hanley. My concern with the upgrades is our purpose is to make sure that the standard is met. It's not to make sure that all possible noise is eliminated.
Right.
And so, you know, I don't believe that by performing upgrades to reduce the noise is part of the requirement to meet the standard.
Other counselors? Leave the language. Counselor Condon?
A question. My lack of knowledge on transmission lines. Do transmission lines generally degrade and get replaced from time to time? And if so, does the department have a role in that? Is that an amendment process? Or I guess the first question is, do they degrade over time, and would you expect more corona noise as time goes on?
That is nothing that I have ever heard. What I have heard is that damage to the line can cause corona. Now, I will say that transmission lines do get maintained. I mean, for nicks and scrapes and all the types of things that can happen with a 300-mile line, they do need to get maintained on a regular basis. But I've never heard that they degrade over time such that corona would begin to increase. And I'm going to look back and make sure that, okay, I got the go ahead that was correct.
Yeah, my expectation is that Idaho Power maintains its line, its assets. And so that goes without saying. It was just the degradation of the line over time.
Yeah.
Okay, so we're saying no changes to noise control condition 3 are needed. Okay, Counselor Choctoot.
Yeah, I think the document needs to stay the same.
Okay, thank you. So we move on then to condition 4.
Actually, STOP had proposed an addition either to 3 or as a new 4 that essentially requires the development of a monitoring plan and data collection plan for corona noise at the 41 NSRs that have already been identified over the life of the project. So STOP's concept here was that we already know that those from the modeling that there's likely to be a problem there. The utility should develop a monitoring plan for over the entire life of the project for those locations. It may be that if agreements are reached and upgrades are done, there doesn't seem to be a problem, but the utility should monitor them because their data already shows that there's likely to be a problem at those key NSRs, and that at the end of each 10-year period of operation, the certificate holder should do an assessment to determine if there is new technology that would further reduce corona noise or problems, and advise the department on that. And to the extent that our STOP's view is that your standards are, you're trying to protect the public health, welfare, and safety and noise situation. And so because technology changes, in order to meet that standard, you have to require or you should require the applicant to stay up to date on technology and to report to the department on upgrades or changes in technology.
Mrs. Rackner?
We have the same response, that we believe that the complaint process is the correct process. And I just do want to remind everybody that those 41 NSRs will have received mitigation at that point. If at any point they believe that the conditions have changed such that something new is required, they can make that complaint.
Okay, council, you've heard both sides. Nothing from council. So any language changes needed? 2 heads no over here, 3, 4, 5, and Councilor Choctoot.
If this is the appropriate time for that language change, then I think we need to make it. But for the document itself, I believe it covers it. That's how I read it.
Councilor Choctoot, we can't hear you. Can you speak up a bit?
You can't hear me?
We're turning your volume up a little, see if that helps. Try again.
Can you hear me?
Yes.
Much better.
Okay.
So, yeah.
Go ahead.
Yeah, go ahead.
Oh, okay. If it needs to be changed, I think we need to change it. But how I read it, it covers everything as it is. And for the future, we can't really dictate what's going to happen.
Yes, I think we agree. Okay, so council's ready to move then on to condition 4.
STOP did not propose any specific changes to condition 4 or condition 5. We recommended that they be removed because they allow for ongoing issues that we didn't think were necessary.
So no changes to condition 4 or 5. I don't think we need to belay that anymore and can move on. Is that right?
Mrs. Hanley.
Oh, okay. Yeah.
Did we already make a determination on the exception and variance?
That's what this relates to. So
Oh, okay.
our opposition, our suggested removal was because these recognize the possibility of an variance or exception. And our position earlier, as I articulated, was you shouldn't grant a variance.
Yeah.
So to the extent that you have granted a variance, if you're going to ultimately do that in your final order, you should keep them.
Okay.
But as to our position in our exceptions was because they acknowledge the existence of a variance that we didn't think you should grant, they needed to go away. But if you are going to grant the variance, then you absolutely should keep them.
Okay. So I think we can move forward through 4 and 5, and we're now up. Whoa,
That's it.
Through. Yeah. Okay.
Mrs. Hanley, I want to thank both of you for helping us through that process.
Yeah.
I think that was very beneficial for us,
Yes.
and hopefully it was beneficial for you.
Okay. I think I turn it back over to Council Ratcliffe.
So I believe where we're at then is a straw poll on issues 3 and 4 combined, as well as the overall standard.
For the record, excuse me, for the record, Todd Cornett, if the council's ready, I can read the straw poll.
We're ready.
So agree with the findings of fact, conclusions of law, and conditions of approval in the proposed order pertaining to the noise control regulations that are not related to the issues in the contested case, and in the proposed order, in the proposed contested case order pertaining to issues NC3 and NC4 with the following modifications. And this would be specific changes to condition 2, condition 2 sub A, to include language at the appropriate location and the specific language. Notice will include both an easy to understand plain language summary of property owner rights with respect to noise control conditions as well as the noise control conditions. And then also under 2A, complaint plan will be distributed by certificate holder. Again, appropriate language and appropriate location. And then under subsection C, in the parenthetical prior to the first word, which is including, we would add such as. And that is it.
Sounds good.
Perry Chalktooth.
Yes.
Hanley Jenkins.
Yes.
Ken Howe.
Yes.
Cindy Condon.
Yes.
Ann Byer.
Yes.
Jordan Truitt.
Yes.
Thank you, council members.
Okay, I believe now we're ready to move on to the land use standard issues. We've got 9, 5, 7, and 8. And so did I do something wrong there? 9, 5, 7, 8. That's what's on my list.
Okay. Right, I only have 9 and 5.
What was that? Okay. I've got them on here, but not 7 and 8.
That's as far as. Okay, yeah, I think that that's right. So 7 and 8 had we had kind of, the intent was to have covered those along with kind of the procedural issues at the outset, where you know, the recommendation was that there wasn't sufficient substantive information in those exceptions to be able to allow the council to make an informed decision on those. So that's why we ended up with 9 and 5.
Okay. Ms. Tardyweather, 9 and 5.
Testing? Oh, there we go. Okay. Tardyweather. Bear with me as I kind of come out of the noise, and let's go over. So the council's land use standard requires the council to find that the proposed facility complies with the local applicable substantive criteria and statewide planning goals as adopted by the LCDC or the Land Conservation and Development Commission. Applicable substantive criteria is from the affected are the criteria from the affected local governments acknowledged comprehensive plan and land use ordinances that are required by the statewide planning goals identified as applicable to a proposed facility based on the facility type and the applicable substantive criteria. The goalpost in council's rules for that preliminary application is submitted. And so for land use for the jurisdictions where the land use applies, that was 2013. The analysis area for land use is a 1/2 mile from the site boundary. And so that is the area that is, oops, looked at. I wasn't ready for that. And then because this is a long linear facility, we've talked about the jurisdictions that it crosses. It's 5 counties in Oregon. It crosses Malheur, Baker, Union, Umatilla, and Morrow County. There's also some facility components in North Powder and Huntington, Oregon. So those are all of the local governments that must comply with the land use standard. And so the land use section in the proposed order is very long, right? Because criteria, I'm going to go to the next slide here. The table is kind of small, but these are the criteria that are identified by the local governments. The applicant in its Exhibit K also identifies criteria that is applicable to the facility. I'm going to kind of just go through these pretty quickly. My presentation is fairly short on land use, just so we can go and talk to the I don't know, the meatier stuff are the items that are related to the contested case issue. So I'm kind of just doing a quick overview of land use. And this is kind of the layout in the section. There are lots of land use conditions, and a lot of them are, I'm kind of air quoting, typical conditions that would apply to setbacks of certain structures. Same with compliance with local permits, comprehensive conditional use permit submission under each county as per their criteria. So in Umatilla and Union County, as we can kind of see on the top of each slide, I have a summary of the zones that are crossed by the facility. In Umatilla and Union County, the facility does cross forest lands. So under OAR 660-006-25 sub 4Q, it establishes that new electric transmission lines with right-of-ways up to 100 feet are conditionally permissible uses within forest lands. And we're kind of going back to that, going back to the actual final right-of-way width of the facility is anticipated to be the 300 feet in forest lands, and that is to ensure that there's enough vegetative clearance for hazard trees, and this is a safety and fire prevention part of the operation and maintenance of the transmission line. So this is related to that wider right-of-way in forest lands. The transmission line would satisfy OAR 660-625 for sub Q. However, the permanent access roads that would be necessary to service the transmission line in operation, those would be located within the 100-foot right-of-way for which the structures are allowable. So the applicant requests that the council take an exception to the statewide policy embodied in Goal 4 for the forest lands in Umatilla and Union counties. And Jesse will go over those more in more detail, but that's just kind of the set up background for that portion. So this is in Union County, which has the same note about the forest lands. And then Baker County. I think, shout out to Umatilla County over here. Hi, guys. And Union. Oh, Scott left. Okay. All right. So, and this is just a really high level overview. And that is basically my presentation. Unless council has any specific questions to the proposed order, we can pass it off to Jesse.
Floor is yours, Mr. Ratcliffe.
Thank you.
Sorry, for the record, Kellen, I did have a couple conditions here. I'll just leave them up here. And this relates to the wider right-of-way in forest lands. And then there's also the right-of-way clearing assessment, which talks about, has that built-in agency consultation. And this is the applicant's proposal for maintaining vegetative clearance in the utility right away. Let me make sure. Okay, now I'm done. Sorry.
Thanks. So issue LU9, the limited party is Myers. The issue is whether the applicant adequately analyzed the risk of wildfires from the operation of the proposed transmission line, especially during red flag warning weather conditions, and the impact the proposed transmission lines will have on Mr. Myers' ability to use an aerial applicator on his farmland. So in the hearing officer's proposed contested case order, she first provided a definition of what a red flag warning is. It's a forecast warning issued by the National Weather Service to inform the public, firefighters, and land management agencies that conditions are ideal for a wildland fire combustion and rapid spread. Red flag warnings are often preceded by a fire weather watch, which indicates weather conditions that could occur in the next 12 to 72 hours. The National Weather Service has developed different zones across the nation for providing weather alerts, such as red flag warnings, to more discrete areas. These zones are monitored and are factored into the applicant's determination of whether to initiate a public safety power shutoff. So a little bit of background on what that is. So the hearing officer's opinion concluded that the risk of wildfire during red flag warning weather conditions was adequately evaluated in the 2022 wildfire mitigation plan, which was submitted by the applicant during the contested case. The potential fire risk zones along the proposed route were evaluated in that mitigation plan. The hearing officer found that evidence on the record demonstrates that the distance between structures, the height of structures, and soil type result in low risk of the potential for large dust devils to interact with a transmission line and cause a fire. Based on review of the data regarding fire size and cause in the area, which is Morrow County, the likelihood of a catastrophic project-related wildfire during operation is very low. Therefore, there is no need for the applicant to have a soil rehabilitation plan in place in response to potential fire-related damage to agricultural soils on Mr. Myers' property. Hearing officer found that the applicant provided expert testimony that evaluated the fuel source on Mr. Myers' property, including herbaceous grass and grain vegetation. Based on this fuel source, any fire on or near Mr. Myers' property is expected to be low intensity and fast-moving. Given wind conditions in this area, low-intensity, fast-moving fires do not cause significant damage to soils. Hearing officer found that the applicant identified potential impacts to agricultural operations, including accessibility to fields for aerial spraying. Specifically, under the agricultural mitigation plan, the applicant would be required to work with landowners, microsite the line, siting the line along the edge of fields or existing rights-of-way, and negotiate right-of-way easements. Finally, the hearing officer concluded that ORS 215-275 sub 5 does not require that there be no impacts from the transmission line to agricultural operations. The potential impacts to aerial spraying have been identified and evaluated, and the preponderance of evidence demonstrates that the applicant will generally reduce the intensity and frequency of impacts to farmlands. Okay, that again is the summary of the hearing officer's findings and conclusions with respect to this issue, and we're ready for Mr. Myers' oral argument.
Directly whether the applicant adequately analyzed the risk of wildfires from operation and during red flag warnings. I request that you reverse the ALJ's decision. Specifically, the ALJ was incorrect in finding that Idaho Power adequately analyzed the risk of project-related wildfire during red flag warning, weather warning conditions, and in operation as well. It's clear in the IPC's 2022 fire mitigation plan that they failed to include the zone that poses a highest level of risk. That zone is over our farm. That's a Weather Service designated zone over our farm. It's not a zone that you talked about prior to this. And that groups weather issues that are similar, issued by the Weather Service itself. The IPC failed to include our zone as a critical fire zone risk or risk zone. They failed to include this. This zone includes our cropland, our farm, and this zone also makes up 25% of the proposed transmission line length. The IPC misclassifying this zone as a critical fire risk again. This zone has statistically the same number of red flag warnings issued on average as other zones that were classified as high critical fire risk zones. In addition, the ALJ was incorrect in finding that high winds pose little risk for wildfires caused by transmission line ignition. In my supporting evidence, I presented in multiple filings showing the 500 kV transmission lines have ignited fires in comparable landscapes. Idaho Power has confirmed this fact. Furthermore, the ALJ was incorrect in finding that if a fire were to occur on my farm, it would have minimal soil impact, and there's no need for the IPC to have a soil rehabilitation plan in place. Quite frankly, contrary to Idaho Power's expert witness, Mr. Madison, the facts provided in my direct testimony are 100% accurate and specifically unique to this cropping system. As supporting evidence, I provided a signed written testimony of a local farmer that experienced a fire in his cropland. That fire impacted his soil negatively for over 6 years. This is a well-documented testimony that completely contradicts Mr. Madison's findings. It is very clear that a much larger risk exists than what was assessed. In essence, the risk on our section of farm has not been addressed, and certainly not as adequately. Judge Webster was incorrect in finding I did not timely offer testimony from the article by Zuhulin Gu into the hearing record. I presented this article within the filing deadline in my declaration testimony, and it is critical evidence, crucial evidence related to my issue. It should not be overlooked.
Mr. Myers, you need to wrap up.
By leaving out this zone over our farm plays out in a number of different ways, but we are at risk of soil damage in a fire. Fires do happen. These lines do light fires. That's a fact. And our environment locally is at risk. Because we don't have a large history of fires in our area, is because we got lucky and because local residents are diligent about not mishandling fire in any way to have a fire take off. Things will change if a transmission line is installed. It's a different environment. You can't say that because we haven't had fires prior to this, that it's not an issue. We just got lucky and we've had people that care about not lighting a fire by accident, and it does happen. And we haven't had a lot of, we're very rural.
Okay, thank you very much. Are there questions from council? Councilor Byer?
This is Counselor Byer. We just touched on the fire component, the wildfire component of your exception. But if you could give us 20 to 30 seconds on the aerial application and your concerns vis-a-vis the power line and how you apply to your property.
Absolutely, absolutely. The IPC has tried to mitigate that with the lines going around fields and so on. They mentioned that, right? In my case, it runs right through a a section and a half of ground that has been continuously farmed for 60 to 80 years. I'm stuck with a line going right through my field. What am I going to do? I can't, it's like there's no mitigation here. It goes right through it, right through the middle of it. I don't even know if I can farm it. I can't, what am I going to, the pilot's not going to want to go anywhere near that. I don't know the regulations there. For my case, it is a disaster. There's no great option. I appreciate that question immensely. I really do.
Thank you, Mr. Myers.
Good morning, Lisa Rackner for the record. Mr. Myers' exceptions raise a number of issues, and I'm going to try to briefly address each of them. But before I do that, I just want to provide a little bit of context about the company's wildfire mitigation plan and public safety shutoff plan for de-energizing lines. The company needs to, sorry about that. The company filed its most recent, its 2022 plan with the Public Utility Commission, and that plan was approved. Now, our understanding from Mr. Myers' exceptions was his concern that the public safety power shutoff plan doesn't include risk zone 461. That was an issue he brought up for the first time. Our understanding is that risk zone 641 includes Morrow and Umatilla County, and I do want to assure the council members that in the wildfire mitigation plan itself, the company has thoroughly addressed wildfire risk in those counties. With respect to the public safety shutoff plan, again, that's the plan for de-energizing lines in certain emergency situations. That is a living document. It only covers the transmission lines that have been built. It's because it's dynamic and it has to always change. So B2H has not been added to that plan yet, but it certainly will before it's energized, and the company will have an appropriate plan for that, the PSPS. So Mr. Myers also alleges that the hearing officer erred by failing to consider evidence concerning the risk of fire ignition with respect to 500 kV lines. However, there was substantial evidence in this case by our expert addressing this issue, and as Idaho Power's expert witness explained, fires from extra high voltage lines like a 500 kV line are extremely rare. They're much less likely to cause fires because they're subject to stricter engineering and safety requirements. They're high above the tree line, and there are much wider right-of-way around it. So the hearing officer correctly found that the risk that a fire would be started from a 500 kV line was extremely low. With respect to, I know Council Member Byer wanted to know about the aerial spraying and the issue there. My understanding is that there is, B2H is planned right now to be routed through Mr. Myers' farmland, that was unavoidable. There were a number of other constraints that led that to be the case. My understanding is that micrositing of that line is available, but to the extent there is some impact on the aerial spraying operations planned on his plan, and we acknowledge that there will be, that will become part of right-of-way negotiations, and there will be discussions about compensation for the diminution of value of his farmlands for that reason.
Thank you, Ms. Rackner. Are there questions from council? Okay. Council Rowe.
Anything I add would just be in addition to comments that Ms. Rachter made. The hearing officer considered Mr. Myers' arguments. She found that Idaho Power had adequate.
We lost the volume. We lost sound. Anyone?
Yeah, can you hear me? For the record, this is Perry Chalktooth.
Oh,
Can you
yeah,
hear
I
me?
can only hear you. I can't hear them.
I can't hear him either.
Okay.
Yes, you can hear us?
Now I can.
Now we can, but for about 45 seconds, we could not. So the starting. I don't know what happened, but no, we cannot hear you again.
Crystal, can you hear us?
Now I can.
Okay.
Well, I could hear whoever was talking. Now we don't hear anything.
Oh, well, we're not saying anything right now.
Okay.
Counselor Chalktooth, Counselor Chalktooth, can you hear us?
I can hear you now.
Okay, sounds like everybody's back on board. This is Patrick Rowe, Department of Justice. Just two brief comments. Again, the hearing officer did find that Idaho Power had adequately analyzed the risk of wildfire. She cited to the wildfire mitigation plan with regard to the aerial spraying issue. In addition to the measures that Ms. Rachter referenced with regard to potential compensation to Mr. Myers. Department would also point out the recommended land use condition 14 would require the certificate holder to finalize and implement an agricultural mitigation plan. That plan is described in attachment K1 of the application for site certificate. It includes measures to avoid, mitigate, repair, and or provide compensation for impacts that may result from the construction or operation of the project on privately owned agricultural land.
Okay, council. Does anyone feel there's changes needed to the language of land use condition number 9? Councilor Condon.
Cindy Condon, and this is to, I think, Mr. Myers and Ms. Rachter. I'm a little bit confused, and I think it has been mentioned, but the substantial disagreement about the zone being adequately, this specific zone that Mr. Myers, on Mr. Myers' property, it just sounds diametrically opposed. No review or no analysis, and then
I think that the keep wanting to use the one that's broken. I think it's a disagreement about what it's called. So in the wildfire mitigation plan, Idaho Power did analyze the area the B2H is going to be going through. So, and we felt that that was adequate, and we do feel that that was adequate. In his exceptions for the first time, Mr. Myers brought up, he said, well, you didn't look at this whole zone. And that was the first time we had ever heard that. He also was specific that we hadn't brought it up in the power safety shutoff portion, which is a different document. But to the extent perhaps he meant you didn't consider it at all in the wildfire mitigation plan itself, I think the answer is we didn't say we're looking at this zone. We said we're looking at the route that B2H goes through, which would be the zone of concern for the purposes of our analysis. So I think we may just be crossing each other. I guess that's the answer if Mr. Myers is really referring to the wildfire mitigation plan itself. If Mr. Myers is, as he says in his exceptions, really concerned about, well, what's in your public safety shutoff plan? What is your plan for de-energizing lines in the Morrow County, Umatilla County area? Then the answer is, Mr. Myers is correct. We don't have that in our public safety shutoff plan yet, because that's a living document, as is the wildfire mitigation plan, but particularly the electrical consequences of shutting off a plan. It's just very technical, and it's going to be very specific to the line that you're talking about and what that line is connected to. So V2H would not yet be included. It is a living document. It will be included.
Thank you. And I do understand the difference between the power safety shutoff. But is Mr. Myers still here? I just want to be clear. In his remarks today, at least I don't remember that he mentioned specifically the power safety. I heard it as the wildfire mitigation analysis.
That's what he said today, and that's why I answered the way I did.
I just want to be clear that we might be able to get some agreement that no, it was adequately or not analyzed. So
I don't see Mr. Myers in the room.
Thank you.
Okay, with that, does council feel there's any changes needed to land use condition 9? Hearing none, I think we're ready for the straw poll.
Okay, so it would be to agree with the findings of fact, conclusions of law, and conditions of approval in the proposed contested case order pertaining to issue LU9.
Sounds good.
Ken Howe,
Yes.
Ann Byer, Hanley Jenkins, Jordan Truitt,
Yes.
Perry Chalktoot,
Yes.
Cindy Condon.
No.
Thank you, council members.
Okay, Council Ratcliffe, it's back to you.
Okay, so our other land use issue is land use issue 5. Limited party is Irene Gilbert. The issue statement is whether calculation of forest lands must be based on soil class, or whether it is sufficient to consider acreage where forest is the predominant use. This was addressed by the hearing officer on a ruling on motion for summary determination, as a number of the other issues that the council has been considering over the past few days have. Once again, that means that the hearing officer reached a conclusion that there were no materials issues of fact, and that the issue is appropriate for disposition on an interpretation of the law. The hearing officer's ruling concluded that Ms. Gilbert did not provide an adequate explanation as to how or why the Union County Comprehensive Plan or the Union County zoning ordinance are not compliant with Goal 4 of the state's land use process. The hearing officer found that Ms. Gilbert did not previously claim that Union County applied an incorrect cubic foot per acre per year standard, or that Union County incorrectly identified the soil class in its comprehensive planning map. nor did she cite any applicable statute or administrative rule requiring Union County or the applicant to use a soil capacity standard of 20 cubic feet per acre per year when determining the predominant use and differentiating between farmland and forest land. The hearing officer concluded that Union County Planning Director testimony from Mr. Mark Hartel confirms that the applicant worked with the Union County planning staff to determine the predominant use of each of the 61 parcels located in the timber grazing zone and used SSURGO soil data, the Union County tax lot data, and GIS software in making that determination. The hearing officer found that the amount of impacted forest land acreage specifically is not material to the Goal 4 compliance analysis, and that overall there were no issues of material fact on this issue. So that's the summary of the hearing officer's ruling on motion for summary determination as it appears in the proposed contested case order. And that brings us to oral argument from Ms. Gilbert.
To appear here would be humorous if it were not so sad. Let me get to my. The contested case here and the dismissal with summary determination and the findings of fact from the administrative law judge are absolutely not correct. Summary judgment is not permissible if the opposing party demonstrates there are factual disputes going to the merit of the challenged agency decision. I did do that, and she indicated the statements that she made are just flat out incorrect. This contested case is regarding whether local land use rules that fail to comply with the state land use rules can be used to determine forest land. There are three of you with experience in land use law. Can you ethically make a determination that a county planner can use county rules over state statutes when they conflict with one another? Scott Hartel, in his deposition, said this is the only document that he used to identify what was forest land in the combined area. It shows only land that has 67 cubic feet per square acre or greater as forest land, did not even evaluate most of the land that is being called range or agricultural land. So anyway, there are multiple disputes of law. The overlying issue is whether the 2008 and 2011 land use rule changes apply when a local government fails to update local land use regulations within 1 year, as is required by the statute. Is the developer required to determine soil capacity for all soils in the combined ag timber classification? The answer is yes. The Union County planner stated that was the only document that he used to identify forest land. The hearings, I'm just amazed. Anyway, the council needs to approve an exception to the summary determination on this issue and allow a contested case to move forward or remand to the hearings officer to correctly identify forest land per the LCDC rules, evaluation of changes to related council rules. They need to evaluate the changes to the related council rules that are impacted by this forest land decision, including LC 7 and LC 8. Lisa Rackner even stated that there would be a relatively small number of issues that could be handled through summary determination, and then the administrative law judge went ahead and approved all 33 that were requested. We have disagreements of fact. The proper identification of forest land is critical to landowners. It has a significant impact on the payment Idaho Power must pay to landowners when they condemn land for the transmission line. One Malheur County landowner said he was offered $3,500 for a 100-year right-of-way for a road that crosses approximately 1 mile of his property.
Ms. Gilbert, you need to wrap it up.
Anyway, leaving these landowners vulnerable to that kind of offer is not ethical. It's not, it's just not okay. So I guess, thank you.
Thank you. Any questions from council? Okay, thank you.
This one will go to the Supreme Court.
So as Ms. Gilbert says, this was an issue that the hearing officer disposed of on a motion for summary determination. In her DPO comments and petition, Ms. Gilbert had argued that Idaho Power and Union County failed to appropriately determine forest lands in Union County based on soil class as is required by the Union County rules, but instead made an evaluation of what land should be designated based on the current use of that land. But as the company demonstrated in its motion for summary determination, that simply wasn't the case. So as some important background, the only impacted forest acres in Union County are located in hybrid forest farm zones. Union County requires Idaho Power to determine whether the impacted parcels in the hybrid zones should be considered forest land or farmland, and then apply the relevant land use standards based on the predominant use of the impacted parcel. Per the Union County zoning ordinance, predominant use is determined by soil type, and that's exactly how Idaho Power, working with Union County, did determine it. So the unrebutted evidence in the record shows that to determine the appropriate soil classifications for each lot, Idaho Power worked with Union County to analyze the soil data based on the Natural Resources Conservation Services Soil Survey Geographic Database, which people refer to as SURGO. Excuse me, which was consistent with what was stated in Mr. Hartel's deposition. Any lot with soils consistent with forest lands were designated as such. Now, there were some parcels for which there was no soil data available, and Idaho Power just conservatively assumed that was forest land. Now, when Union County reviewed these determinations, including a review, they included a review of the current use of the land, but there were no parcels for which that predominant use changed forest to agriculture land. So contrary to Ms. Gilbert's arguments, the determinations of forest land were made entirely based on soil type. Now, in her reply brief on summary judgment, Ms. Gilbert did raise a different argument. Instead of asserting that Idaho Power failed to rely on soil type, she now argued that Idaho Power used the wrong approach for its soil analysis, and she argued that Union County failed and Idaho Power failed to apply what she believes to be a state planning rule that any parcel consisting primarily of soil types with timber production capacity of 20 cubic feet per acre must be considered forest land. However, Ms. Gilbert never identified any state statute or regulation to support that position, and that's why the hearing officer rejected her argument. And I see I'm out of time, but if you have any other questions, I'd be happy to hear them.
Thank you, Ms. Rackner. Questions from council? Okay. Council Rowe.
Crow, Department of Justice, on behalf of the Department of Energy. As has been discussed, the issues related to Union County zoning code issue. Evidence on the record shows that the applicant properly consulted with Union County on how to interpret and apply the requirements of that code. Union County Planning Director testified in the contested case and affirmed that the applicant's approach to evaluating both farm and forest lands in Union County was appropriate. So the department agrees that it was appropriate for the hearing officer to dismiss this issue on summary determination.
Any questions from council? Okay. Does council feel that there's any changes needed to land use condition 5? Hearing none, we're ready for the straw poll.
Okay, so this will be for both the land use standard and issue LU5. So agree with the findings of fact, conclusions of law, and conditions of approval in the proposed order pertaining to land use standard that are not related to the issues in the contested case, and in the proposed contested case order pertaining to issue LU5. Jordan Truitt,
Yes.
Hanley Jenkins,
Yes.
Kent Howe,
Yes.
Cindy Condon,
Yes.
Ann Byer,
Yes.
Perry Chalktoot.
Yes.
Thank you, council members.
Okay, we have a few remaining items, adoption of minutes and some other things. Do we want to break for lunch and come
It is
back, or go ahead?
Entirely
and plow
council's
through?
discretion. So we have a couple remaining things for this agenda item, and then the two minutes, the draft minutes for the two council meetings. So it is entirely your choice if you want to push through or if you want to take a break and come back.
What's council's pleasure? Get a little food and then come back and work through it?
Sure.
Working lunch, okay. We'll take a 15-minute break and be back. Do we need 15? Or do we want 10? Start at 12:30 or 12:35? 12:30? Okay, 12:35. We'll come back. Okay, I'm calling the council back to order. Yeah, so we're ready. I'll turn it over to Secretary Cornett.
For the record, Todd Cornett, thank you, Mr. Vice Chair. So we have one holdover issue, and that is give me 1 second. That is the structural standard. So at near the beginning of day one, on the structural standard, council had some questions. There was some interest in a condition related to notification related to blasting. And so thanks to Christopher Clark, we tasked him with doing some research. He found some information related to the Oregon Department of Transportation, provided that to us. Sarah was able to package that into condition language. So I have proposed condition language. Yeah, actually, I can just read it, or if you'd like me to share it on the screen, what's your preference? Okay, maybe I'll just email it to you. Okay, give me 1 minute, please. Okay, should only just be a minute. Give you a chance to eat a little bit more too. So I'll work on the preamble. So this would be to agree with the findings of fact, conclusions of law, and conditions of approval in the proposed order pertaining to the structural standard that are not related to issues in the contested case, with the following modifications to be included in the draft framework blasting plan, section 3.3.2, blasting notification and safety procedures, which is an existing section of the plan under recommended soil protection condition 1. And then the specific language we'll bring up on the screen. Okay, and you can see it, but I will read it. So this would be in addition to the notification that was previously in there in the newspaper, not in place of it, but in addition to. So at least 14 days prior to any blasting necessary during construction of the facility, certificate holder shall ensure that its construction contractor identifies all landowners of record and occupants within 12 150 feet of blasting actions and provide notifications to those landowners and occupants, which I spelled incorrectly, of the blasting schedule, potential hazard or potential risks and hazards, and of measures that will be taken to monitor and minimize any ground shaking impacts.
Any comments from council?
For the record, this is Councilmember Byer, and thanks to staff for addressing this issue. I know we heard testimony earlier today that this really doesn't get at the heart of the issue, but at least people will have notice and understand that there will be some impacts to their neighborhoods. So thank you to staff.
Councilor Condon?
Thank you. I'm just wondering if it would be beneficial to have as part of the notice contact information. So, should you have concerns, contact information, contact Idaho Power, the blasting company. I don't know who would be contacted, but I'm wondering if that would be helpful.
What does the rest of the council think of that suggestion?
Jordan Truitt, I guess it depends on who sends the notification out and who the appropriate contact would be, whether it's a blasting contractor or, but yeah.
I presumed it would be the Idaho Power.
Right. And I don't know otherwise.
Does that look good, council? Okay.
Yeah.
Okay. So what action do you need from council? Do you do a
Straw
roll call
poll as well.
Roll call? Okay.
Yep. Cindy Condon,
Yes.
Ken Howe,
Yes.
Jordan Truitt,
Yes.
Perry Chalktoot,
Yes.
Ann Byer, Hanley Jenkins.
Yes.
Thank you, council members.
All right, so that has taken us through all of the exceptions and oral argument. We have also gone through all of the standards now between the July and August meetings. Where that is going to take us to is now, based on the results of those straw polls, some work on the part of myself and the staff to incorporate some of the recommended changes that the council would like to see. We'll be putting together a document that will incorporate those changes. And where we have, as the council's probably familiar with, when we get to this kind of draft final order stage, there are a number of kind of scrivener's corrections that are just meant to reflect the fact that this is a final document instead of a proposed document. So there will be those sorts of changes, but in addition, where we do have these proposed changes to conditions in particular, that will trigger this material change hearing, where there will be an opportunity to comment on those proposed changes specifically. So when we get back together again, there are going to be a couple of components here. It will be a review of the draft final order, and then this material change hearing, and then that will ultimately culminate in the council's vote on the site certificate. But before we get to leave this agenda item, there's one other housekeeping thing that I want to note here. And that's
Jesse,
that.
I'm sorry to interrupt. Sorry to interrupt. Before we get off the Scrivener error
Sure.
issue, I just want to point out that I've just been conferring with Secretary Cornett that if any of the parties or limited parties have Scrivener error corrections that they would like to suggest, that they do so, and we believe a week from today.
Okay.
Appropriate. And that would be Scrivener error corrections to the proposed contested case order or to the proposed order.
All right. Thank you for that clarification. So the one other housekeeping thing I wanted to note was in reference to a comment that I made towards the beginning of the meeting where I was going over some of the procedural issues that had been raised on the contested case record. And one of the issues had been some conditions that had been proposed at closing argument. And we just went through some of those conditions here with Mr. Anuta and Idaho Power with regard to the noise standard. Most of the other conditions the hearing officer had addressed as saying, I don't think these are timely filed. However, you know, here are the other reasons that I am not planning to adopt them if she didn't plan to adopt them. And essentially the reasoning on all of those was the conditions that show up in the proposed contested case order and the proposed order are sufficient as they are. The ones that have been adopted, they're sufficient as they are to demonstrate a finding of compliance with whatever the council standard is that's in play, whether it's land use or waste minimization or whatever it is. There are a handful of those conditions that she did not add that extra sentence onto. However, by implication, the reasoning is the same. She didn't adopt the conditions because she had separately concluded that those standards had been satisfied with the conditions that were in the proposed order or proposed contested case order. And so I just wanted to note that for council, that is probably, you know, something that I would suggest that in coming back to you with the draft final order, that we take that implicit, you know, reasoning from the hearing officer and make that explicitly consistent with her statements with respect to the other conditions, just so that we don't have a reasoning gap there as it exists in the proposed contested case order. So if there are any questions on that, ask away, but that's all I have on that one.
Any questions from council? Any action needed today from council?
No, other than just kind of a, you know, a head nod that we're headed in the right direction on that one.
Yeah.
Okay.
Councilor Byer?
Timing, calendar, just curious.
That's a good question. For the record, Todd Cornett. So what we're the next council meeting, which I think I may have missed that in my secretary report. We're looking at September 27th, which is a Tuesday. We'll be in Salem, so either remote or in Salem, as available for council members. And we would then be getting the draft of the final order at least 2 weeks ahead of time. We'll try to get it out earlier than that, but we're already on the clock. So that would hopefully give council members and Idaho Power and limited parties the opportunity to look at that. We will identify any material changes. So, structurally, you're looking at the proposed contested case order. What then happens is those get folded kind of together in a way to become the draft of the final order, which you will then be looking at. And as we talked about earlier, any material changes that are identified, and we will call those out specifically so people don't have to comb through it to kind of figure out where those are. There will be a material change hearing. So, those who want to make comment on those can. And then if council is ready, you could be issuing a final decision during that council meeting in September.
Cindy Condon, just a quick question. Monday, I think it was Monday, we discussed some language where would was replaced for will and agreed to change it there. And I should have brought it up at the time, but I think that's used throughout the proposed order. And if staff could just take a look at that for the same reason.
Yeah, again, for the record, Todd Cornett. So Sarah Esterson responded to that. And the way she had responded to that, you know, the documents as they're moving through the process are either the department's documents. So the draft proposed order, that's ours. The proposed order, that's ours. The proposed contested case order, that's the hearing officers. The final order is your document. And so the way we structure some of the recommendations on findings, we recommend counsel. Well, so there's a lot of language like that that gets converted from those, you know, documents that are moving up through the process that are not your documents to the final version, which is your document. So we will make those changes within the final, or at least the draft of the final order.
Thank you.
And so kind of head nods from council regarding the superfluous conditions being removed and brought back to us in the September meeting.
I'm sorry. I just wanted to follow up on the will would and for the record, Kellen Tardyweather, did I say that? And Todd's absolutely correct. A lot of the tenses and the recommends and the order language, all of those change when in the final order. And I think that we have flagged where you identified it with, you know, relative to that sentence and wanting to change it to a shall. But this is like the using would instead of will. It is, I guess we do that for all of our projects and all of our documents. So, and it doesn't necessarily mean that every would is going to turn into a shall, because some of it is actually just temporal. It's just like, because even in the final order, it's still, it's still a going to do. So it's like, so I just want to be very clear. It's not every wood's going to turn into a shall, because some places it just won't make sense. It's just kind of the tense. We do it anyhow. It's just like a tense of how we include in the documents.
Thank you. And I just want to reiterate. So would to me is a conditional element. And so the would do if applies. And so will or shall or must is not as conditional. And so I just want to be clear about that. That's the issue.
So for the record, Todd Cornett, thank you. We absolutely totally agree with that. And to Kellen's point, you know, I mean, if it's in a condition and it's being a mandatory, you know, in those we absolutely will, shall, you know, but again, and depending upon, you know, other circumstances, you know, it may be the word would may be the appropriate word. So we will evaluate all of those in context of, you know, the structure of the findings, the conditions, whatever it is. And any of those changes will be in strikeout. So you will be able to see those.
And I'm just responding. Mr. Anuda just handed me a note about the material change hearing, and it is a hearing. There will be an opportunity for comment. And that I was trying to scroll through the details of how that hearing is supposed to work. I didn't get to it on the fly quite fast enough here, but I think that the point here is that for the interested parties, that when we send out notice of the meeting, all those details about the opportunity for argument and comment on the material changes will be included.
So, Mr. Chair, does that material change hearing occur on the 27th?
So what constitutes, for the record, Todd Cornett, what constitutes a material change is, you know, can be fairly narrow. So it's not everything that the council decided is going to be a material change, but we will, you know, thoroughly evaluate that and again, call out what those material changes. So, you know, at this point, I can't tell you if it's 3 or 15, you know, but we will call those out and those will be available for oral comment.
Didn't we decide a year ago the shalls become must?
Yeah, there was some conversation about that. I
There
do not
was.
recall. We'd have to go back and look at that.
Just remember that.
Yeah.
Okay, then is the next item,
If I
We-
may, if you'll
okay.
allow me, just before we conclude, agenda item B. So the work involved for this agenda item was monumental. And I know everybody knows that. But I think it's worth stating for the record that the amount of effort put in by everybody, by the limited parties, by Idaho Power, by Department of Justice, by my staff, by council, this has been monumental. The amount of time and effort preparing for this meeting and then going through this meeting is very, very significant. And so I just want to call out to everybody, my appreciation for the commitment, the time, the complete effort put into this. I know not everybody's in agreement on all of the outcome, but I just want to recognize the serious effort that went into this. So thank you to everybody who participated in this.
I second that. Okay, so we're ready to move to approval of minutes as going back to the June 23rd, 24th meeting minutes and the July 22 meeting minutes. Do we have a motion?
I so move. This is Hanley and as prepared.
For both dates?
Yes.
Is there a second?
This is Jordan. I will second.
Okay, ready to call the roll, Secretary Cornett.
Give me 1 second. Kent Howe,
Yes.
Ann Byer, Hanley Jenkins,
Yes.
Jordan Truitt,
Yes.
Perry Chalktoot,
Yes.
Cindy Condon. Yes. Motion carries, Mr. Vice Chair.
Is there any other business for the good of the order?
Mr. Chair, there's no more business from staff's perspective.
Anything from council? Okay. The time is now 12:57 PM and the August 29th, 30th, and 31st, 2022 meeting of the Energy Facility Siting Council is now adjourned.